What up, though? What up, though, Biz Nation? It's your boy Tay Biz. What's going on with everybody, man? How y'all doing? We are back. We are here. This is the weekend is over. We are. This is Monday. You know what I'm saying? Even though I got the Monday blues, it's kind of like it's an overcast here in Indy, and it kind of sucks. But nevertheless, we're gonna go ahead and get started with the show, man, and get things popping. Let's go ahead and clap it up real quick. See who we got in the building. We got She Lee, first of all, saying hashtag Biz Nation. Shout out to She Lee, man. And thank you again, She Lee, for the information that we discovered, I guess, Friday, I believe, where about the plea deal situation with Young Thug. And so definitely appreciate you holding it down as always. Shout out to Drea as well. All the mods sent me some information. I mean, again, Weinstein told us he was going to have a motion for us, and he does. And we're gonna go ahead and get into it, man. I ain't gonna lie, the title of his motion is actually funny to me. It's hilarious. Wait till y'all see it. It's crazy. But shout out to Fresh Chocolate in the building, saying peace, love, blessings. She said Business Nation. Let's go. Business Nation. Let's go. Oh, we got the wonderful Cat Not Williams in the building. What up, Doe? What up, Doe? Appreciate you. Man, Cat, you are. I'm gonna tell y'all something about Cat for real. Cat is a sweetheart, man, and she saw that my channel is almost at 1,000 subs, and went on X and mentioned me and made sure that people knew like my link and all that kind of stuff on X. And I really appreciate you, Cat, for real. Like you really do support a lot of people, and you really do hold it down, man. So I really, really appreciate the love that you show to us small YouTubers. You know what I'm saying? Like, really, I'm at the crib with a t-shirt on right now because I ain't got to do no more work for the rest of the day. You know what I'm saying? So just to be able to come through and do what we do, man, it's like it's a lot of work to do this too as well. But thank you, Kat, once again for your love and support. I appreciate it. Sheila said, like, comment, share, and subscribe to get all of the information or informative information here at Biz Nation. All right, Fresh Chocolate showing love. She Lee saying good morning to everybody. Oh yeah, Fresh Chocolate said love Cat. Love Cat Now Williams is awesome, man. I mean, and because of the love and support that she shows, she's going to be nothing but blessed on her channel. I mean, that's why her channel is growing. That's why her channel is blessed, because she blessed other people all the time. You know what I'm saying? So shout out again to Cat. We got Devora in the building saying good morning, Biz Nation. I'll be here in the background. That's what's up. That is what's up. Wait till we talk about this motion, man. Man, Doug's motion. I'm not gonna lie. When I saw the title, I started dying laughing. I am not gonna lie. I started dying laughing like, yo, this dude is a character, man. This dude is a character. But I had to thank him though. I mentioned him on X. I had to thank him because this motion, I'm telling you, that he submitted, I don't know if it's gonna get denied or not. At this point, who knows with this judge? But he made great points, nevertheless, in this motion for the public to see, and everybody knows that this case has been dragged out for not just the case, the trial. The trial itself has been dragged out for months. Okay, we're going into it'll be before you know it, September 2024. They've been doing this since last year, 2023, in November. I think the opening statement was November of 2023 when the opening statement started and the trial actually began officially. And so to go from November even to now, and you're still case in chief, you still submitting evidence, you still calling witnesses. Come on, man. And then you're giving us stuff that don't even make any sense. You got witnesses that you're trying to put prior inconsistent statements on, and you're like with Lil Woody, you know what I'm saying? You haven't even called other witnesses like Sledge yet. You haven't even called them yet. Whoever the person who did who was supposed to do the plotting for the cell data, you haven't. I don't think they came into question. I'm not even sure if they're on the witness list or not, but I believe they will be called at some point. But dude, this is getting to become a soap opera instead of an actual trial. So this makes no sense to me, to be honest with you. And so Yeah, but this motion is definitely on point. So we're gonna go ahead and get started. Let me go ahead and drop this banner real quick. If you haven't already, go ahead and like the video, like the stream, and you always support liking the stream is really what supports us the most. You know what I'm saying? And so yeah, let's do that. let's do that. Let's go and do this real quick. Like, share, subscribe. Let's go. Look, this is the motion right here, man. All right, this is Doug Weinstein. He filed it at midnight. All right. Um, and look at this title, man. This title says, and this is again, if those of you that don't know, Doug Weinstein is Yak Gotti's lawyer. All right, Yak Gotti is the one to sit directly in the front of the court, not right to the side of where the prosecution table is at. And Doug Weinstein be right there sitting next to him. All right. He's mostly quiet for the most part, but when he do speak up, and he speaks up and he articulates himself very well for his client. It says in the Superior Court of Fulton County, state of Georgia versus Diamante Kendrick. Look at the title. Motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence. Yo, man, yo. The title. Now listen, I know Brian Steele will give us some long titles, but this title right here, motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence. All right, check this. Listen, this is like this is motion gold. Shout out to Doug Weinstein, man. I mean, because he said he was gonna file some motions over the weekend, but this title right here is hilarious. All right, it is hilarious. And this is something that we've talked about on our channel here, that again, we're trying to figure out, when does the prosecution stop presenting their case? The judge said, I'm talking about Whitaker. Whitaker said that she wanted to end this trial somewhere around March 2025. Do y'all remember her saying that? Do y'all remember her saying that? She said that she wanted to stop this case, or she wanted this trial to end around March of 2025, at least by March of 2025. The prosecution has been case in chief since November of 2023, people. Okay. So when will the defense be able to be case in chief? When? This is absolutely unbearable. All right. Let's go ahead and read it real quick. It says the defendant, Diamante Kendrick, by and through his undersigned counsel, without waiving any other rights to which he is entitled, files this motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence, stating the following. I haven't read this whole thing, so we all gonna do this together. Okay. I wanted to do this with everyone. All right. I read some of this, but I ain't want to do the whole thing. I ain't want to read the whole thing because I want to make sure that I wanted to do this with you all. Okay. It says here, as this court has broad discretion to exercise reasonable control over the presentation of witnesses and evidence, the court should use that discretion to prevent this trial from stretching indefinitely and beyond the reaches of time due to the state's unpreparedness and inefficiency and presentation of cumulative evidence causing undue delay, poor decision-making by the jury, as well as harm to Kendrick and other defendants. And there's a footnote there. What did the footnote say? The footnote says a similar but not identical motion requesting limiting the number of states' witnesses to less than 400 was filed with Chief Judge Glanville in March of 2024. with the judge granting some limited relief, which has generally not been followed by the state. Okay, now this is actually very important. This part right here, poor decision making by the jury. All right, when you're talking about overloading information to the jury, you're overloading. It's like you're doing overkill. Like seriously, think about if you were on the jury right now. How much of this stuff could you actually remember? Like seriously, if you, I'm talking about, even if you're taking notes, you're talking about being in court for 8 hours, and you have seen about 100 witnesses hit the stand since November of since November up to this point, until your break had started. It's like, how can you retain all of that information if you're a juror? Yeah, you could take notes and all this kind of stuff, but man, that's going to be a lot of notes to take. And I'm not sure if they get a new notepad every day or every other day. I've never been a juror before on a trial. Yes, I've had to report for jury duty and to be selected for a juror, but I've never been selected, thank God. All right. And so this is a good point actually in this motion, that the state is so unprepared and inefficient, and they're presenting cumulative evidence, and it's going to cause undue delay and poor decision making by the jury. The jury has to deliberate on everything that they have looked at or have seen and heard in the court from the genesis of this case, of this trial, until the next year of March. What I mean, at the rate that the state is going, they're going to be case in chief until November. They had to slice down their witness list again with this judge. Even 100 witnesses is still kind of crazy. You know what I'm saying? So this is a very good point by Doug Weinstein. I got to give him his props on that. That's actually not a bad point. Is that this is going to cause poor decision making by the jury if we continue, if we let the state just overlap and overdo their time. All right. Simply put, excuse me, the court should put a reasonable time limit or clock on the remainder of the state's case. Absolutely. 100% agree. If you agree with this, put a 1 in the chat so far. I mean, just this paragraph alone is great. Is really, really good. Like, this court, you got to put a time limit on this, man. Like, we have been doing this for a long time with the state. All right. It got to stop at some point. The state has put and continues to put this court, these defendants, and these 16 jurors through an arduous, tedious journey. Dang. Hold on. He using big words. Hold on. Arduous. Let's look at it real quick. Involving or requiring strenuous effort, difficult and tiring. Yes, very, very arduous. New word alert. New word alert. All right. Arduous and tedious. Y'all know what tedious mean, but arduous is for sure a great way to describe this case. The court should put an end to our forced march, even as the state will likely contend that we should blindly trudge on and trust that the next months will be different, that the state will develop the speed and efficiency of our finest Olympic athletes, and that the finish line of their snail-like marathon is in sight. Oh my goodness, Doug. Is Doug frustrated or not? Is he? I mean, the level of just sarcasm in this is crazy. Oh my goodness. He said the speed and efficiency of our finest Olympic athletes, and that their line of their snail-like marathon is in sight. Like, okay, we're almost close. We're almost close to ending. Like, yeah, sure. At this point in time, this honorable court was born witness to the state's unpreparedness and lackadaisical attitude toward any type of diligent approach to moving in a deliberate fashion toward a conclusion. That is true. That is definitely true. All right. The state, this court has been born witness. All right. You have walked into uh you have walked into a bunch of BS, basically is what he said. Look. This is hilarious. All right. Doug Weinstein is hilarious. He has quoted everything that came out of the judge's mouth about the prosecution. How can this be denied? Listen, we're gonna see. We're gonna see how this motion goes. I hope she don't deny this because this is ridiculous. But why should the state have any need to move with deliberate speed? That's a good question. The state returns home to their friends, families, and loved ones at the conclusion of each day. The state lives their lives, goes to work, and get their paychecks no matter how long this trial proceeds. Woo! Meanwhile, for Kendrick and the other defendants, every day is Groundhog Day. Oh, but instead of waking up to Sonny and Cher, he wakes up to the, somebody help me out with that, cacophony of Rice Street and the ritual of heading to court. Jeez, oh Pete. Yo, he is not playing on this, man, for real. See here, a harsh, discordant mixture of sounds. Oh, yeah, a cacophony. Oh, wow. Yeah, that's a great way to describe that as well. Your boy Doug gonna give you some words now, okay? Look at this. The state returns home to their friends, families, and loved ones every day. It don't even matter. Basically, look, they live their lives, they get their paycheck. It doesn't matter. But all these defendants, they wake up to possibly getting shanked, possibly getting, I mean, all kind of stuff. And Rice Street is the worst. Fulton County Jail is the worst jail in America. All right. And they just taking their sweet old time with this case, basically. The U.S. Supreme Court has explained the critical role of the trial judge in a criminal case. Our cases have consistently recognized the important role the trial judge plays in the federal system of criminal justice. The judge is not a mere moderator, but is the governor of the trial for the purpose of assuring its proper conduct and of determining questions of law. A criminal trial does not unfold like a play with actors following a script. Woo! There is no scenario and can be none. The trial judge must meet situations as they arise, and to do this must have broad power to cope with the complexities and the contingencies inherent in the adversary process. To this end, he may determine generally the order in which parties will be adduced proof. His determination will be reviewed only for abuse of discretion. Look here. It says the judge may refuse to allow cumulative, repetitive, or irrelevant testimony. If truth and fairness are not to be sacrificed, the judge must exert substantial control over the proceedings. Is that Jeters versus the United States, 425 US 80, 86-87, 96? Wow, even states a case here. I mean, just think about this. Just think about this. It is the prosecution's job to ensure that there is actual evidence being presented, right? Not cumulative, repetitive, irrelevant testimony or things, or like establishing foundation to make sure that everybody knew each other. Remember when Hilton first started questioning Woody after he decided to testify? She just kept sending him pictures of him over and over again around Shannon Stillwell or Lil D or Yag or whoever she was trying to, I forgot, it's been so long, but whoever she was trying to establish foundation with, she was trying to lay the foundation that Woody knew these people, and she just kept doing overkill. It went from Instagram posts. Then it was a video with everybody in the same room and they was talking on the video. Then it was another video. Then it was another post. Then it was another post. And it's like, how much of this are you going to do? You've been laying foundation for 2 or 3 days. This is ridiculous. This is absolutely ridiculous. Once you establish that this person know this person in a certain manner, then you are good to go. Then you can start laying, after you laid foundation, then you can start piling on the evidence of what you believe that that they're alleged of, okay, or accused of. You just piling on things over and over again. It's the same thing, and you've been doing this since November, man. This is crazy. So it says internal citations omitted, emphasis added here. It says here, the state, after originally proposing a witness list of over 700, no, you what? 700 witnesses, has a list of over 100 witnesses. It still intends to present at trial. Okay, they got 100 witnesses they want to present at trial at this point that we at right now. They cut it the 700 down to and it's still 100 witnesses. Jeez. What specific evidence the state intends to use with each respective witness remains unclear. Remains unclear. A very generalized description of subject matter to which each witness will testify has been provided. No end to the state's case in chief is in sight. That's what I've been saying. How many of y'all have been watching this channel or the live or going back to it or whatever the case? I mean, you may not be able to watch it live, but maybe you go back. You will hear me say all the time that this is a lopsided trial. You can't be case in chief from November 2023. And when is it going to, let's say it ends in October. And then the judge is saying, oh, I want this trial to be over with in March 2025. So you mean to tell me from October, November, December, January, February, you give the defense 5 months before you want to end this trial. You done gave the state 11. It's ridiculous. It's absolutely insane. Thank you, Doug. Thank you, Doug. Everybody put Doug in the chat. Put Doug in the chat, man, for this motion. All right, this is simply untenable for the remaining 16 jurors or the defendants who remain jailed and without bond, and the presentation of another 100 witnesses by the state would cause undue delay, would be a waste of time, and would amount to needless presentation of cumulative evidence. We got some footnotes we're going to look at. Hold on. Footnotes right here. It says here we have the situation described so clearly by Judge Bertelsmann in his oft-cited 1986 decision on limitations imposed at trial. The judge remarks with this insight: it would seem that early in the career of every trial lawyer, he or she has lost a case by leaving something out, and thereupon resolved never again to omit even the most dang, I can't even say this word right now. I'm so tongue-tied. Inconsequential. Thank you. There it is. Inconsequential item of possible evidence from any future trial. Thereafter, in an excess of caution, the attorney tends to overtry his case by presenting vast quantities of cumulative or marginally relevant evidence. In civil cases, economics place some natural limits on such zeal. The fact that the attorney's fee may not be commensurate with the time required to present the case thrice overimposes some restraint. In a criminal case, however, the prosecution, at least in the federal system, seems not to be subject to such fiscal constraints, and the attorney's enthusiasm for tautology, excuse me, I'm tongue-tied today, y'all, sorry, is virtually unchecked. So this is wild. I mean, this is actually makes sense here. I mean, you're talking about the fact that when it comes to the state and things like that, it doesn't matter. You could just, there's no limit. You know, I mean, you're gonna get paid anyway, like Doug said, you're gonna get paid anyway. You can do the trial as long as you want to, but you have to respect the fact that this is taxpayers' money. You also have a fiduciary responsibility to make sure that you're not wasting the money of the people going after a certain case, all because you want to make sure that you dot every I, cross every T while the trial is going on. That's not how you're supposed to do that. So definitely feel that footnote there. As put so succinctly by the Third Circuit Court of Appeals, courts need not allow parties excessive time so as to turn a trial into a circus. After all, a court's resources are finite, and a court must dispose of much litigation. In short, the litigants in a particular case do not own the court. That is the fact. I mean, because DA Love, I'm sorry, Chief Deputy District Attorney Love, she believes that she is just like she owns it. Like the court's supposed to do whatever she wants them to do. You know what I'm saying? This trial has become a circus. If you think, I mean, how many of y'all believe this? How many of y'all believe that this trial has become a circus? It has. It's like, okay, when are we going to get to the evidence? When are we going to see some things? You're talking about RICO. Okay, where's the contraband? Where is the conspiracy to do some organized crime? Where is all of this at? And you have taken, look here, it says excessive time. Trial is on its is into it has become a circus. The court's resources are finite. So, and a court must dispose of much litigation. It's overkill. Likewise, the prosecution here does not own this honorable court. This honorable court has broad discretion on the presentation of evidence and should limit the introduction of duplicative or unnecessary witnesses by the state, as noted by the Georgia Supreme Court. A, provides the trial court with broad discretion to exercise reasonable control over the presentation of witnesses and evidence to avoid needless consumption of time. The Fifth Circuit, the predecessor to our 11th Circuit, has also recognized the ability of a trial court to limit the number of fact witnesses at a criminal trial where those witnesses' testimony would be cumulative. Exactly. You're having people come on the stand and they're all saying the same thing. They're all saying the same. They're all repeating each other. They're all saying the same thing. Upholding the limitation of the number of fact witnesses allowed to be presented to testify to the efficacy of a party's treatment methods. Here we go. Furthermore, this court can limit evidence under Rule 403 of our state's rules of evidence. Okay. Relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. This is 100% facts. Confusion of the issues. This is a big piece right here. Just think about this. If you are on the juror, if you're a juror and you're on the stand and you've been a juror from the beginning, right? And here it is, August 19th, 2024. How much of this trial would have been confusing to you? Now you're the person that's supposed to be deliberating at some point to make sure that you present a verdict that is just. that is just based upon a fair trial. Not a lopsided trial, but a fair one, right? How many people could say, hey, this is a fair trial? I can actually deliberate this fairly with all the information that the state has given us. With these videos of what he'd been doing, the music lyrics, the opening statement, the witnesses, all these police officers, all these detectives, even the people from Hertz rental vehicle was on the witness list. And what did they contribute to the case? They asked the one man, Brian still asks, if I come to your rental car place with someone else's ID, can I still rent a vehicle? The man didn't even know how to answer that question. The man said he didn't know. Like, come on, guys. Like, what contribution are these witnesses giving even to your case? None. Thus, there is also a basis under either Rule 611A, 2, or Rule 403 for this court to exercise reasonable control and discretion in placing a time limit on the state's case to prevent undue delay, waste of time, needless presentation of cumulative evidence. It has never been supposed that a party has an absolute right to force upon an unwilling tribunal and an unending and superfluous mass of testimony limited only by its own judgment and whim. Facts, man. In exercising its reasonable control over the presentation of witnesses and testimony, Kendrick also urges this court to consider the ramifications of the present pace of trial and its impact on the jury, the case, as well as the defendants. What's that footnote right there? The footnote right here says Mr. Kendrick is not requesting that this court limit the number of witnesses that are crucial to the state's case. Speaking to the federal rules of evidence, Rule 403 does not mean that a court may exclude evidence that will cause delay regardless of its probative value. If the evidence is crucial, the judge would abuse his discretion in excluding it. So he's basically saying, look, I'm not saying that the state needs to get rid of all their witnesses per se, but the crucial ones, they should stay. But the ones that are not crucial, why are we even giving it any type of time or leeway? Okay? Like, why are we doing that? Why are we giving it any type of attention? If this witness is not a crucial witness, because we are way past the crucial part of this trial. We are at the critical stage of this trial right now. Okay? If any witness cannot contribute to this stage, why are we still letting them testify? Like, they should just go home. You know what I'm saying? They shouldn't even come to the court. So I feel him that he's even trying to be fair in his request. All right. It says here, we're right here. It says, while there is no doubt that the new court is moving this case along at the fastest pace possible, given the court's meritorious, I believe I said that correctly, excuse me. Pretty much the court's merit, recognition of the limited recognized right of the state to present its case in the manner it deems best. The prospect of another 100 plus witnesses leads to several undeniable conclusions. This trial will last well into 2025 if the state is permitted unlimited time to present its case. Courts outside of Georgia and the 11th Circuit have recognized the impact on a jury of a lengthy trial merit consideration. For example, as the 7th Circuit has approvingly quoted, exceedingly lengthy trials lead to reduced concentration and recollection of events on the part of all participants, particularly witnesses and jurors. This is 100% true. The longer the case, the more we're not interested anymore. And that's what the jury is probably sitting there like, I don't even care about this case anymore. I would like to hear from the defense at this point. I mean, when are we even going to cross-examine Woody? Now Hilton said Friday. Now all of a sudden Friday there was technical issues. So that means when it's time for the jury and for Woody to come back to court, the state is still going to be questioning Woody and putting in this evidence, doing all that kind of stuff. I mean, it's ridiculous. It's overkill. It's overkill. In very long cases, exhaustion may diminish everyone's performance. The quality and representative nature of the jury may be reduced by the fact that many citizens, often the most competent, are unable or unwilling to take the time to sit for cases lasting weeks or months. United States versus Warner. Says that quoting Gordon Van Kessel, adversary excess in the American criminal trial. It says in Warner, the court also notes that jurors become overwhelmed by the volume of evidence and numbed by its repetitiousness. Their attention flags, their minds wander. The witnesses, there were more than 100 in the trial of 2 defendants, get mixed up with jurors' minds or forgotten. The profusion of exhibits makes the documentary record unintelligible. The impressions created by the closing arguments are likely to wipe out everything that went before. Jury comprehension has been found to diminish after a mere 20 days of trial. Finally, and not meaning to belabor the point, the court in Warner wisely notes, so now imagine jurors' mental state after 6 months, bearing in mind that memory loss and the psychological or cognitive problems of jurors in a super long trial compound the first problem, the difficulty of recruiting competent jurors for protracted trials. A less intelligible trial is heard by a less capable jury. The longer the trial, moreover, the likelier jury misconduct becomes. Okay. The jurors become bored, impatient, irritated. The judge's instruction against discussing the case before the jury retires to deliberate because increasingly irksome and likely to be disobeyed. Says while the state puts on its case, witness by witness, Kendrick and the other defendants sit in jail, their lives on hold, the clock ticking on their lives, second by second, minute by minute, hour by hour, day by day, month by month. Meanwhile, the risk of a confused jury unable to comprehend a years-long trial only grows. Wherefore, Mr. Kendrick respectfully requests that this honorable court to place a reasonable time limit on the amount of time that the state has remaining to put forth its case in chief. Yo, shout out to Doug Weinstein for that. I mean, he makes a very valid point. He makes a very valid point with this motion. We are at the we are at the critical point, critical stage of this particular trial here. You know what I'm saying? And you still have over 100 witnesses. You know what I'm saying? You still have over 100 witnesses. The court is almost going to start in a minute. You still have over 100 witnesses on this list. You are prolonging the evidence or the cumulative evidence. You're just adding on more than what needs to be added on. And so the defense is just sitting there waiting. And meanwhile, while the prosecution is presenting their case, the jury is getting restless. Okay. They're getting restless, and rightfully so. How many of you all are restless already? Like this whole trial, this is day 114, technically. All right. Even though there's no jury today. But today is 114 of this trial since the trial has started. We have not heard the defense's case in chief yet. We have seen a few them cross-examine some witnesses here and there, but it takes forever for them to get to cross. So at this point, it's like, dude, what are we actually doing right now, man? What are we actually doing right now? Shout out to everybody watching the live right now. I really appreciate it. But yeah, this is absolutely insane. That this is continuing to go on. So this motion, do you think that that the judge is going to deny this motion? Look, Sheely said Whitaker will deny all of the motions. Oh, shout out to Sheely, man. Abundance, what up, though? Abundance, I appreciate you. She says, this trial has done nothing but show how corrupt the court system can be. If it did anything, it did that. I don't even like seriously. I have not seen any evidence of anything. And I was talking about this last night with someone that they have like information that hints around the idea of something, but in the court of law, you have to prove. You have to prove with evidence. Okay. And that's just the way it is. This is our system. This is how our court system roll. Even if they are guilty, you got to prove it. And if you don't prove it, it's up to the jury. All right. It's up to the jury. So breaking it down with B says, yeah, I appreciate you. Oh man, yes. Yeah. So she's gonna deny. Y'all think she's gonna deny it? Yeah. Too true. I appreciate you, too true though. What's up with you? Corruption, especially in Fulton County. Absolutely. Do you know? I found out something that Fulton County has been paying Cobb County, or has paid them so far $11 million to house the inmates, or the overflow of inmates in Fulton County, because I think Fulton County only supposed to hold like I think a couple thousand, or maybe one or 1,000 or something like that. They've gotten so many of men in jail, and I'm talking about men in jail that have not even talked to a lawyer yet. Men in jail who's actually unindicted, who hasn't even been charged with anything yet. They are going to Cobb County, and Fulton County has paid, as of what I read yesterday and what I researched yesterday, $11 million. Oh my God. I was burning so bad. Too True said, just subscribe. Thank you so much for subscribing. I appreciate you, Too True. Thank you so much. Thank you so much. I really appreciate your subscription. I hope I do you right. I hope I do you well. Yeah, the $11 million to Cobb County. And remember, I did a video on this channel. It's called Woody Speaks. It's like my largest video that I've done. And in that video, Woody talks about how they transferred him over the weekend when he pled the fifth. They transferred him from Rice Street to Cobb County, and they put him in a hole, and they didn't give him no food, no water, or anything like that. And then that Monday, he had an ex parte meeting. Excuse me, and he hadn't even eaten any food or anything yet. That is what he said that had happened.
We got one more minute before
That's
it's
the
afternoon.
full video of Professor Nez. I know
Anybody
he
know where the
interviewed
steak
Ashley Merchant.
is?
Yeah, yep. He interviewed Ashley Merchant, and it was very interesting. So, okay, I'm gonna check it. I'm gonna go watch it.
We appear to
Go
be
watch it.
missing lots
I'm gonna
of
take some notes on that.
leaders.
Yes, I remember. Yeah, when Moody said that, and he's telling the truth. He was telling the truth on that. They couldn't put him in Fulton County, so they put him in Cobb. $11 million, man. That's crazy. All right, we are in court. Court is in session. Let's see what happens. Again, there's no jury. All right, there's no jury at all. And okay, I appreciate it, Abundance. Thank you. Yeah, email it to me. There's no jury involved today. It's just defendants and the counsel and the judge. So let's see what they talk about today. I'm gonna go ahead and be quiet, put myself on mute. Red Buddy, what up, Doe? What up, Doe? If I'm not mistaken, I believe either one or two things. I think either the jury this week had off because Glanville already sanctioned it for them to be off this week. But I do know there was a half a day because something that the judge had to do too. So, but I could be wrong. Somebody fact check me on that real quick if you can.
Yeah. Thank you.
Once again, we got another subscriber for Biz Nation. Thank you so much, Too True. Once again, I really do appreciate you subscribing to the channel. And again, I hope I serve you well with this channel. All right, we do a lot of fact checking around here. You know what I'm saying? So we try to make it do what it do. So thank you so much again for your subscription and your time. I appreciate it so much. Thank you. Reason said waste. Yeah, waste of time. Absolutely, waste of time. Yep, exactly. Yep, Glanville gave them the week off, so that's why they're not there. Yep. So thank you for fact checking me, Brad Bunny. I did mention that. I wanted to make sure I was right. I appreciate it. All right, seem like they're still discussing things amongst themselves. Where is the state at? The state is late. What's going on? So, how many of you all agree with that motion from Doug Weinstein? I think the motion that he made was on point and on time, for real, for real. There was another motion by Brian Steele that we do have. We can get into that a little bit later if we have time, and it has something to do with the fact of the Breton motion about ensuring that nothing that a defendant says that's on trial goes against Mr. Williams or Young Thug. So we could dive into that too a little bit later as well. So I want to read it real quick just to give us a little bit of context. It says here that the Breton Rule prohibits the introduction of a non-testifying co-defendant's statement during a joint trial that implicates the defendant. The rule implies to any statement that would be testified to, such as statements made to the police officers, statements made after determination of the conspiracy, and statements that are not co-conspirator statements. The rule is limited to facially incriminating statements. Okay. So a non-testifying co-defendant statements during a joint trial that implicates the defendant. The Bruton Rule prohibits those type of things. So anything that's in Yak Gotti's statement that mentions Young Thug in any type of way, those statements are prohibited because they're joint defendants. It's this, breaking it down with me says the state and Brady traded. They should look. They ought to be okay. Shoot, man. They need to be. This whole thing need to be dismissed. And there's something about, and this judge does this all the time, where she's like, "Well, we fixed that problem now, so it's not Brady." Yeah, it is still Brady, man. Case dismissal. We need Judge Summer in the court. Judge Summer threw that case out for Baldwin, man.
None of the defendants have been fed lunch yet. We're going to break, let them quickly be fed, wait for the state to get here, and then get started. So we'll be in recess before accomplishing a single thing.
Judge, what? All right, we are in recess. Why are we not surprised? All right, let's look at this. Let's look at this Brian Steele motion while she's doing that. I do not like her attitude, man. I'm sorry, man. I do not like this judge, man. I'm sorry. I don't like condescending people. I don't like condescending people. They have, it's 12 o'clock. They ain't been fed no food, no lunch. Jesus. Oh my God. Everybody to like, what the heck? Exactly. They're waiting for the state. The prosecution is late. They're waiting for the state to arrive. The judge is so, I don't know who she thinks she is, man. But Judge, you are the weakest link at this point. Yes, Gen C. Thank you, Gen C, for watching. I appreciate you for watching, Gen C. She says she allows it. Yes, she allows. This is exactly what I'm talking about right here. This is what Doug was talking about right here. You allow anything. You allow anything. The state can do whatever they want. And it's cool. And it's cool. And that's the problem. This is the problem I have. I have a problem, man. Cherry on top. What up, though? Appreciate you. One of our faithful members of Biz Nation says, "Do you think she is protecting the state and the old judge?" Oh, absolutely. 100%. 100%. I do believe that. I do think that. I definitely think that without a shadow of a doubt in my mind, especially Glanville, because when you tell the defense that I need to see your questions before you ask them, because Brian still wants to question Woody about Glanville's behavior and things that he said. I don't see why. You see that she wouldn't even let Glanville be on the witness list, even though he was a witness to his own ex parte meeting. Man, look, man, this is crazy. This is crazy. Cherry on top said, "I'm new to this area, but it makes sense to me." I mean, I don't see no other alternative but the fact that she's trying to protect the state and protect them from what exactly, you see? So yeah, she said, so she just, yeah, they all crooked. They all crooked. Listen to me. They all crooked, man. We got to remember the judge, these are political positions. These are state paid positions. You have to be elected to be a judge in this particular, in superior courts and all that kind of stuff. You have to be elected. You have to run for judge. It's a political aspiration. Now, some people are just satisfied. Some people honestly want to be judges and want to further their career in that aspect, which is cool. 100% cool. I get it. You know, like they dreamed of being a lawyer, they dreamed of being a judge, all that kind of stuff. But it's a very political position, especially and it's political because you have to have the backing of your peers, basically. So in the state of Georgia, I did research and see that they are allowed to support each other financially. I think judges have to pay a certain amount of money and lawyers have to pay a certain amount of money, whatever, a reasonable amount. I think the limit is about, like, from what I read, it's about close to maybe 6,000 or something like that. That's like overkill though. Judge Glanville supported Judge Krause before. He gave her $2,000 for her campaign to be elected judge. Brian Steele and Bruce Harvey hosted a re-election party for the judge that's on the case right now. They all know each other. They all know each other. So, you know, the system is crooked, and so that means the players in the system have to play crooked to the system. See what I'm saying? So, yep, that's how it goes. That's exactly how it goes. All right, let's go ahead and look at this motion, man. All right, so this motion was filed on August the 16th at 4:01 p.m. So okay, Abundance, you said you emailed it to me. All right, let me look at it because see if it's on Professor Nez's channel, I can't use it because he has restrictions on his channel, so I can't necessarily play it if it's on his channel. Let me take a look at this real quick first. Yeah, it's on his channel. Yeah, it's on his channel, so I won't be able to play it because he has strict restrictions of his content. He doesn't allow other content creators to utilize or use his content. So I won't be able to play it for us because I would love that. Uh, I know that I saw some clips on X and I was able to see the. I actually reposted one of the interview that he did with Ashley when she talked about the trial and the time frame and things like that. So I won't be able to utilize. I won't be able to look at. I won't be able to play off his channel for us to look at it, but I will look at it myself and I will try to see what I can do to get around it. You know how we do. You know how we do. Oh, don't worry, we'll figure it out. We'll figure it out. You know how we do. Let me look at the chat. The chat is on point, man. Shout out to is that Suraj Latif. I hope I'm saying that correctly. If I'm not, I apologize. Trial over? No, it's not over yet. Oh, somebody already answered you. Okay, cool. No, the trial's not over, it's just on break. It's on break as soon as it got started. Okay. uh EKPM LLC, I appreciate you for coming through. Says they're about to be voted out. Absolutely. I hope so. I hope so. I mean, if I was in Georgia, man, I would be so upset right now. I would be so upset right now, man, for real. Hot Wayne, what up, Hot Wayne? Say, nah, humans are crooked. uh, Jen C said, I am not a conspiracy believer usually, but I swear I saw hand signals and the judge made decisions based on those signals. I swear I saw them. You are absolutely correct. As a matter of fact, we touched on that before. And I was trying to find one day some videos that I had of I had some videos before of hand signals between Hilton and Glanville. All right. So you're absolutely correct on that. You're not, that's not a conspiracy. What you saw was actual, believe your eyes. Always believe your eyes. You saw what you saw. You saw what you saw. Okay. Definitely. You saw that. You saw those hand signals being done. As a matter of fact, hold on, before we get into this, let's do this real quick. Because actually, I was given some information from one of the people in the comments. And shout out to Paralegal Institute of Washington, D.C. Made a video about the very thing that you're talking about, Jen C. We about to go ahead and take a look at it. Matter of fact, we'll do that. Okay. We will do that. Uh-huh. Sorry, guys. Give me 1 second. Let me get to the video. Let me get to the video. So there is supposedly there was some more hand signals done with this judge. Now it seems a bit. I don't want to. I don't. I'm because I am objective as well. I'm not just. I'm not just. I'm just not. I'm not going to just dive in fire because everybody else is. So they're talking about. They're talking about some hand signals being done with Judge Whitaker between Hilton and Whitaker. Now remember, and I'll chat rock with me. Everybody watching. Remember, I believe either Thursday or Friday or whatever, or the day that Woody had the blue jacket on. That was Tuesday. There was a nosebleed, remember? All right. And right before the nosebleed, there was some signals being done. And, hey, we're going to check it out real quick. We're going to check it out right now, as a matter of fact. We're going to check it out right now. All right. We're going to check it out right now. So this is Paralegal Institute of Washington, D.C.'s content. So I'm going to credit it to him. And somebody from the chat, if you can, please put the link to Paralegal Institute of Washington, D.C., put their link to the channel. And let's see what so people can subscribe to the channel and things of that nature. Someone gifted you a membership, cherry on top. Okay, I appreciate whoever gifted the membership. I appreciate it. Thank you so much for doing that. I didn't get no notification of that in the chat, so maybe somebody did that before on a different channel and it still stayed with you. I'm not sure. But let's check this out, because the bailiff says something to the administrative assistant, and the administrative assistant says something to Whitaker, and I guess there was some type of signal from Hilton to Whitaker. All right, let's just check it out and see real quick. All right, let me know. Let's see what you see. All right, let me know what you see. Okay. Let's go. Let's play this real quick.
Video, you're going to see a suspected situation during this week's trial where Hilton sends a hand signal to the judge. And we're also going to review a previous suspected situation in which Hilton sent supposedly a hand signal to Glanville. And we're going to take a look at it and break it down. So sit back, relax, and let's get into it. A couple of days ago, Woody was testifying and being defiant as always. And at one point he says, "Me no speak no English," right? And I thought this was funny. So I made a quick little YouTube short out of it.
2015, were you mentioning any of Thug's songs? Was your nickname Woody mentioned in any of Thug's songs?
Huh?
Did Thug mention you in any of his songs back in 2015?
Back in 2015?
Yes, sir.
I don't know.
Okay. Do you recall telling the detectives that he put your name in these songs and he doesn't know, you don't know why he put your name in these songs?
I didn't like him rapping about me.
Why didn't you like him rapping about you?
Huh?
Why didn't you like him rapping about you?
Because it's my life. Like, don't be lying on me.
What do you mean by that?
Don't be lying on me.
Are you talking about in the rap songs?
Yes.
What did you think were lies that he was telling on you in the rap song?
I don't recall.
Do you recall what the verse was or what he said in the rap song?
Ain't no speak no English. No, I don't recall.
And I didn't really think anything else of it. But as you can see on the comments from that YouTube short, someone said that Prosecutor Hilton made some kind of signal or some kind of hand signal to the judge. And you will notice, once we play that clip, you'll notice the judge promptly calls for court to take a break. So at Jack Frost P 9201 said, "Did anyone catch Hilton giving the judge a signal to cut Woody off? In the law in seconds, as soon as Woody said, quote, like I told you in that back room, end quote. Hilton looked at the judge and gave her a signal by tilting her ink pen towards her. The judge quickly grabbed the microphone to cut Woody off by saying, quote, we need to take a quick break, end quote, and made up an excuse. She didn't give any indication of stopping until the signal. She's no different from Glanville. And I said, if I can find it, I'll make a video and give you credit. So Jack Frost P 9201, here is your credit. And Jack Frost P 9201 responds, cool, I haven't heard anyone speak on it, so I wanted to make sure that people see that this judge is no different. So here I'm going to play the 2 minutes leading up to and including this hand gesture and the judge calling for a break so that you can get the full context. Then we'll look at it as more like a clip. But Take a look at it in full context here.
Back in June of 2015, did you believe that Thug turned everyone against you?
Huh?
Back in June of 2015, did you believe that Thug had turned everyone against you?
That's why I would tell the police anything to get them off me. If y'all watch me like y'all would, y'all would see that nothing ain't changed but the lies I told the police.
So my question is, in June of 2015, did you believe Thug was trying to get everyone to turn against you?
What do you need to do that for?
Isn't it true that you told the detectives that Thug turned everyone against me?
It's true that I tell the investigators anything that they want to hear. They want to hear about Thug. So I'm about to sit right here and gas them up. I'm about to sit right here and say he killed 19 people, all type of stuff. I'm about to sit right here and make him look like the worst person on the earth so that they can believe and let me go.
And at no point in any of these interviews did you ever tell the police that Thug killed Nut, did you?
Shit, did I?
At any point, did you ever tell any police, if you wanted to make him look so bad, at any point, did you ever tell the police that Thug killed Nut?
Shit, I don't know. I think I don't recall. I can't say what I told him. I can't remember because you trying to trap me up. I can't remember if I told them that he did it. I don't.
Isn't it true?
I know I was gonna get it off of me.
Okay. Isn't it true that what you told the detectives, which is what Demekion told you, was that it was Shannon, Nard, Yak, and Dua?
I don't recall what I told.
Uh-oh.
Okay. Isn't it true that you only told the detectives what D told you?
Here we go.
I don't recall what I told him. I thought that D was gonna back up my story, so I was trying to throw the blame on D to get it off of me.
Okay. And isn't it true that D only told you that the people who shot the shot were Nard, Shannon, Yak, and Dua?
What's going on?
I'll
He
repeat the
said, what's
question.
going on?
Isn't it true that D only told you that it was Nard, Shannon, Yak, and Dua?
Like I told you in that back room back there, D never told me none of that. I made it up.
All right.
You see that? Okay. Now I'm starting. Now it's starting to make a little sense now. But in that back room, I remember this. We streamed this. We streamed the live here on this channel. When he said in the back room, everybody in the chat caught it. Everybody caught that. So is the nosebleed even true? I'm not even sure. I know Miss Sylvia. I know infamous Sylvia is in court every day. I don't know. I haven't seen her say anything about a nosebleed at all when she was there. If somebody fact check me and let me know if infamous Sylvia was able to confirm this whole nosebleed, because it was so random how this happened. And I know that people have been saying that the courtroom is always cold. So if the courtroom is always cold, I'm trying to figure out. I haven't had a nosebleed in a while, but anytime I had a nosebleed, like a random nosebleed, it's because my temperature was up. So I don't know, like, you know what I'm saying? So somebody fact check me. I'm not no expert. No, like, I'm an IT person. I pay attention to details for sure. Okay. And all I know is what the heck is going on here? Check this out.
Like I told you in that back room back there, D never told me none of that. I made it up.
All right,
I don't recall.
we need to take a quick break.
Okay.
What's a quick break?
What's a quick break? I don't know, maybe 10 minutes.
You said 10 minutes? Can I go
Okay,
out?
thank you. Okay,
Yeah,
thank you.
but be back in 10 minutes, okay?
I'll be right there.
All right.
Now let's watch the clip again, but with a close-up on Hilton and on the judge.
D never told me none of that. I made it up.
All right,
I don't recall.
we need to take a quick break.
Okay.
D never told me none of that. I made it up.
All right,
I don't recall.
we need to take a quick break.
Okay.
Now, what was interesting about this is that the judge goes on later to say that the break is due to one of the jurors having a nosebleed. But if you watch the whole thing in context, it does look like it's D.A. Hilton who signals to the judge that it's time for a break.
Sorry, we had a juror with a nosebleed, so they're gonna go deal with that. So hopefully it won't take very long.
Now, again, I'm not here to be a conspiracy theorist. Someone made this comment in the comment section of one of our videos. So I'm just bringing this to the people to see if anybody else noticed this, to see if anybody else has any thoughts about this. Now, previously, there was a time when the same DA Hilton and the previous Judge Glanville apparently touched their ears at the same time. Now, again,
Okay, hold on one second, y'all. Exactly, abundance. Like how convenient. Like I'm just saying. It looks coincidental. It does. It's like, okay, this had to play out a certain way. Now I'm looking at causes. I'm looking at things that can cause a nosebleed, right? So cause number one says dryness. The climate can have a huge effect on the health of your nose. If you live in an area with a very dry climate, such as a tropical area or a desert, then you are more likely to get nosebleeds. Again, people have been saying that the court is cold, like super, super cold in there. As a matter of fact, they asked Whitaker one time to like see if they could change the temp on it and all that kind of stuff. This is because the heat and lack of moisture can dry out the inside of your nose. Cause number two, nose picking. Wow, that's just don't do that. Blowing your nose can cause a nosebleed. That's for sure. If you blow your nose too hard, you can get a nosebleed that way. Or broken nose. Well, of course, we know that. Allergies can cause a nosebleed. See, here we go. I get nosebleeds when it's extremely hot and dry. I tried to avoid Vegas. There you go. You know what I'm saying? So the nosebleed was legit. It's just the timing of it makes it look suspicious. And let me tell you something. When you already look corrupt anyway, everything you do looks corrupt. You see what I'm saying? Like anytime you are, anytime a person, if you ever been around a person and they show you pattern after pattern of them being very, very like shisty, and then they finally try to tell you the truth, even the truth looks shisty. You feel me? Like, because they're so shisty, everything they do now looks shisty, right? So yeah, this is kind of like what it looks like to me. All right. Jen C says, when Woody said what kind of break or something, then why didn't the judge tell Woody a juror had a nosebleed? I don't know why did it have to be that Woody had to step out the court and all that kind of stuff, and then be like, well, there was a nosebleed with the juror, so we're going to go ahead and take a break. Abundance said, just like the timing of Melnick being suspended. Hey, man. I feel you. I feel y'all now. I ain't gonna lie. I feel y'all. You know what I'm saying? It just, again, everything looks suspicious. It just looks suspicious. Hold on. I think I hear the court. Give me 1 second, y'all. I think I hear them coming back from court. We're going to get back to that, though. Yep. Here we go.
All right, so I think that
Here we go.
maybe the first things we need to tackle are whatever the evidence is going to be with our next few witnesses following Mr. Copeland. So I know that co-conspirator statements, as well as all of the other evidence that y'all, the state, intend to introduce with the next several witnesses, has been provided now in detail. So I would propose that that's where we start, unless somebody thinks something else would be more efficient. That work for everybody?
Speaking of cold, my bald head was cold. Got the air on. So I put a hat on, dog.
So have y'all been able to get together on any of it to come to agreement on anything, or are we going to litigate all of it?
Your Honor,
Yeah.
just for clarity, are we discussing the evidence that was shared by Mr. Atkins on Friday night? Is that
I mean, I think there have been a couple of different shares. There was, I also don't off the top of my head know exactly when. There was one, and then there was the supplement, and then there's also, I think, something that Ms. Hilton shared that's in a spreadsheet, which I think covers the same things that Mr. Atkins provided already.
So, I think there's multiple, God bless you, there's multiple things. We
Yeah.
sent the evidence regarding upcoming witnesses a few weeks ago, according to
Right.
Mr. Atkins. What we sent on Friday, Your Honor, was the co-conspirator statements, making sure that the ones that the state intends to use were provided. And then yesterday, what I did was I provided a spreadsheet of the co-conspirator statements that are found within Mr. Garlington's wiretap, which had already been provided, and Mr. Sumlin's wiretap that had already been provided.
Okay.
So I just specified which statements from those wiretaps we intended to use.
Okay, so that's a subset of the bigger set.
Yes,
So,
Your Honor.
I mean, we can start there if y'all want to start there. Or are those going to come in later in the trial?
Those are going to come in later in the
Okay,
trial.
well
Your
then we'll
Honor.
set those aside for now.
Is the 31 through 60 witnesses.
Right.
Oh, I'm sorry. We submitted the 1 through 30 witnesses on August 8th,
Right.
2024.
Okay.
Judge, there was one matter with respect to the PowerPoint. I did send over the redacted one. And I spoke with, as I informed the court, I spoke with Mr. Williams about Mr. Ryan's statement and our intent to not use that.
Right.
So those two matters were off the table.
Okay, so yeah, we don't have to deal with a motion to suppress Mr. Ryan's statement because the state does not intend to use that. And I've also been informed that Mr. Kendricks is not going to be filing a motion to suppress the first hour and a half or 2 hours or whatever of his statement. So we don't have, that's also off of our to-do list.
Your Honor, on
Yes.
behalf of Mr. Ryan, and what was received on Friday, I think was our updated list of the people they actually intend on calling and co-conspirator statements, I believe. So we'll have Mr. Ryan's motions in limine, the basic ones of this is inadmissible hearsay, those types of items based on what we just received. I don't know if those are the immediate upcoming witnesses. We're going to prepare it as fast as we can. We're just kind of, as you know, getting the rolling. This is what's actually being introduced.
And so we, in my speaking with Mr. Williams, I did let her know that if she had specific objections, there may be things that we could agree to. She did name some and I agreed with her. So we were continuing to discuss those. So if after those conversations, Mr. Bassi and Mr. Williams feel like there's still more to litigate, that'll happen. But that conversation and that dialogue has started regarding those things that have been turned over to Mr. Ryan.
I think what probably would be the most productive is things that we have issues on, we make note of and make a record. This is the defense raises this issue, state agrees, so that they've been addressed and it doesn't, something got missed from the list or something like that. So we'll get with Ms. Love and do that.
That's fine.
We'll
that's
get
fine.
that to the court as soon as possible. I don't know if they are in the next few witnesses category or not.
I mean, I don't either right offhand, but if it is, we're litigating that stuff this week.
Right. Could the state provide a little bit of guidance?
No, Your Honor, the stuff for the Jamari Holmes are not within the next 10 weeks.
Okay.
Okay.
All right. That works. How about Mr. Kendrick's statement that there's the Bruton issues on, right? And when's that going to get introduced?
So
State.
not in the next 4 weeks, actually, based on who it is that we intend to come before the witness that would
Okay,
introduce.
what witness will that be with?
Investigator Thor.
Well, y'all got him listed as witness number 5.
We do, but he has had He will be moved down based on some circumstances that have occurred in his,
Okay.
he has some personal matters.
Okay, so is it still gonna be Burnett, Sledge, Zachary, Dean, Morton, Sprinkle, the phone custodians, Bernie, generally?
Generally, yes.
Okay, and then I guess Thorpe will be at the end of those now? Okay.
This is crazy.
And that PowerPoint, that's,
That's with Dennis.
well, that's with Dennis, okay. So he's several out. Okay. All right, so great. That'll give y'all some time to get together on that statement to sort Bruton issues. Mr. Steele, you also seemed to kind of be making a broad argument that nothing in his statement, in Mr. Kendrick's statement, even if it doesn't directly implicate your client standing alone, needs to be redacted, or there needs to be a limiting instruction about that. Do you have any law to back that up?
I'm trying to get proper law, but in this case, there has been over objection, the announcement that YSL is a criminal street gang that Mr. Williams, according to 3 supposed experts, is a member of,
Mhm.
in addition to Trintavia Stevens, said that Mr. Williams is a member of, in addition to Mr. Walter Murphy, had Mr. Williams allegedly as a member of. There may be others. And then in Mr. Kendrick's statement to law enforcement on October 6th, 2015, he discusses YSL, the crew, the gang.
Mhm.
So I think that under Bruton, it's an element of the offense of criminal street gang as well as RICO, that I believe that that does not indirectly, but directly implicates Mr. Williams. But I'm looking for law on that, but that I do not want to waive that issue. In addition,
Well, yeah, just get me some law and we'll take it. Sounds like it's not quite as time sensitive as we thought it was, but we still need to get moving on it. So try to get me the law that would cover that. as
in
soon as you
addition,
can.
I'm sorry.
Go ahead.
No, I
Go
thought
ahead, I'm
we were
done.
Thought the sound record was done. Yes, I do want a limiting instruction, and that comes right out of the cases that I did cite, because that statement I cannot cross-examine. Mr. Adams cannot cross-examine Mr. Kendrick. That statement should be his alone. And it's confrontation clause, so it does not move the conspiracy forward. So it's not a recognized exception.
Okay.
So the second part of the question was, do you have law for the limiting instruction? And I already provided, but I could provide more.
Okay. And then I do want you to get with
boy
the
Steele.
state to try to come to an agreement as to what needs to get redacted to avoid Bruton, at least the classic Bruton issues, and we'll have to take up whether any kind of talk whatsoever about YSL gets included within that or not. But as to sort of the classic, Mr. Williams did this, which I doubt if he says something like that anyway, but something that would directly implicate your client standing alone. Y'all, the state ought to know what that would be and be able to redact that out. And it's going to be played as a video statement, right? So, right or no?
We intended to ask questions.
Okay.
Versus.
That's fine. That's fine.
And Your Honor,
Yeah.
I did that in my motion. I was specific, and I give the timestamp where it starts. And I did it not only for Mr. Williams, but I did it for anybody else that I saw. And I did it for Shannon Stillwell. He's mentioned a great deal as well. So I believe that I flagged. If I missed anything, obviously, I'd like somebody to tell me, but I believe I've already done it. If the state agrees with it, then we need to figure out, make sure that the witness or witnesses know.
Sure.
But other than that, that's been done, Your Honor.
Okay. Thank you.
And Your Honor,
Yes.
while we're on this topic, just an additional issue. not only are there brutal matters, but there's also just typical evidentiary rule matters, such as speculation. At one point, Mr. Kendrick is asked who he thinks may have done this, for instance, and he names some names. That's the sort of thing that would need to come out, brutal or not, if we're asking about speculation.
Okay, well, it sounds like it's not going to be played as sort of a running statement. It's going to be more targeted questions to the, I guess, investigator that conducted the interview.
Correct.
Okay,
So
so,
that would not even be an issue, putting in or trying to redact out
okay,
those kind of comments.
all right, good. All right, so let's turn to some of the.
Well, at least these will redact this speculative
specific,
stuff, so that's
yeah,
cool.
Evidence that's going to be coming in with these next witnesses. So there's not anything controversial with regard to witness Burnett's evidence, right?
Hilton and Love, man. You can tell they got a love-hate relationship.
Everybody else is silent, so I'm going to take that as a no for everybody else. All right, so Mr. Sledge, there are some co-conspirator statements from him. We already did his interview, right? Okay. Did we do his jail calls, or do we still need to do that? Maybe I can look at the more detailed exhibit list that y'all provided to everybody.
Your Honor,
Yeah.
before we discuss the jail phone calls, I do have one possible issue. I'm not sure how the state plans on doing this. I see what is this? The fifth row down on Mr. Burnett, comparison photo infinity Q5 or Q50 and gas station still photograph. I don't know exactly what that means or how the state anticipates that presentation to go in court. I don't know what Mr. Burnett's qualifications would be to compare two photos. So I'm just wondering how the state anticipates that playing out in court.
Okay. So are you looking at the first 30 witness list? Is that what you're looking at?
I believe I'm looking at the same thing as you. It starts with 81 and then Copeland under the witness.
No, I think you've got a more detailed one than I do. I need to find the more detailed one. That was a Dropbox link, right?
Correct, Your Honor. And in regards to what Mr. Shard is addressing, Mr. Burnett, both back in, I forget the exact date, but during Deputy Sprinkle's investigation, he worked at an Infiniti dealership. He's worked for Infiniti for over 20 years. So it's lay opinion testimony. Obviously, the state has to lay the proper foundation when he's on the stand, but
Right.
his ability to recognize Infiniti vehicles is through his 20 years, and he personally has driven Infiniti cars. So obviously that has to come out, but it's not scientific expertise. It's
He's
classic
an
lay
expert
opinion.
because he's got all kinds of daily experience with it from the last 20 years. Or
Yes, Your
whatever.
Honor.
Okay.
What? Come on, man.
Okay.
Y'all can just
So
grab
does
a
that
photo
answer your
from Google
question,
and
Mr. Short.
It does.
Jeez,
So
Pete.
I guess Mr. Atkins, you are going to ask him in front of the jury to compare the two photos and testify whether they're the same type of car. Is that
Correct, Mr. Shard.
okay?
As one piece of his testimony, I mean, essentially, after the foundation is laid, he will use his lay opinion as a 20-year Infiniti rep to state his opinion of what specific vehicles are in both exhibits admitted and, demonstrative photos that are included in that Dropbox link.
I don't know. I would like the Honorable Court to look at the photographs. I don't know if we need a individual lay person to say that these are similar.
Do
There's-
I have, I mean,
Seriously.
you, Mr. Atkins, are saying lay, but then you're describing something that I would think if this is beyond the ken of the average juror, it's expert, even if it's based on his 20 years as an Infinity rep. So which is it?
So, Your Honor, he can be, his experience as an Infinity rep, if he needs to be deemed an expert to state what the vehicle is in specific photographs, it's all through his training and experience of working with Infinity's hands-on for 20 years.
What?
Well, that would probably then be expert, but do you want to show me what it is that y'all are? I mean, I see that one of the things listed is comparison photo, Infinity Q50 and gas station still photograph. Is that what you want me to look at, Mr. Steele?
And
An
Your Honor, some of
expert
the
in
exhibits-
an
so
Infinity rep expert?
There's
What?
the exhibit of the drive-by shooting that resulted in Mr. Thomas's death that is at nighttime.
Uh-huh.
And there's also a lit up the Texaco gas station that's like 50 feet from the crime scene location. So that Infinity vehicle, in the state's belief, is the same vehicle seen in the kind of more lit up gas station and also the vehicle that did the drive-by shooting. And so it is not as easy for just a juror to decide, because of the quality of this 2015 surveillance video, what kind of car that is driving down in either of these. And
So are you going to have Mr. Burnett look at the darker, more grainy drive-by and say, I can identify this as an Infinity because of X, Y, and Z things?
Correct, Your Honor.
But the
Okay.
people that was actually there said it was a
And then
Bonneville
you're
that did the
gonna
shooting.
have him look at the same thing in the gas
Oh my
station
God.
photo and say, in my opinion, this is the same Infinity because of X, Y, and Z things?
Jesus.
He will speak about the make and model of the
Okay.
vehicle. He won't be able to definitively say that's the exact same
Okay.
car.
But you anticipate he'll be able to say, this is the same make and model as the one shown in here, and here's how I know that, here's how I'm able to determine that?
Correct, Your Honor.
Okay.
How many
And
times have
that
we heard
seems
white
legitimate.
Bonneville?
And then obviously the jury will be instructed they can believe it or not believe it, but that seems okay. Okay.
Judge, are you
All
serious?
right. So
This
then
judge is
we
terrible.
have,
Oh my God,
Mr.
bro.
Sledge and his jail call. Did we already do his jail call?
We haven't. I've listened to the jail call. I would object to the jail call. It's Mr. Sledge talking to his fiance or wife about what happened in court. And
Okay.
it's definitely
Is it a
not
relevance objection?
it's not relevant. It's speculation. It's definitely not furthering any conspiracy. I'm not sure why that would be admissible.
Okay.
We would not play that jail call unless there was something that Mr. Sledge says on the stand that contradicts something that he said in the jail call.
Okay.
So, I mean,
So that's just potential impeachment. That's
Right.
not gonna come in during his,
right.
Okay.
Right.
all right, well, I mean, it's still out there as impeachment if that becomes an issue. But we won't, yeah, it sounds like they agree. Okay, and is that it for Mr. Sledge? We already did his interview. So that's the only jail call.
Right.
Okay. All right, so then Mr. Zachary, and we've done both of his statements already. Jail calls and social media. Yes.
Is there an updated, can I ask the court to inquire whether there's an updated contact or address or both for Mr. Zachary? Somebody said that he's in North Carolina. I don't have any contact with that gentleman.
Okay, can you provide, if his contact information has changed since y'all last provided it to the defense, can y'all provide updated?
So the last time before last that we spoke with him, someone indicated that he was, but it appears that he is still in
The same
Same
place
location.
he was. Okay. All right.
The last week, I just want you to know if it matters to the court. Hold on, can I ask this question? We were told that he's very ill. That's what I was told from the detectives.
Okay.
And I was told that he's in a hospital. That was dated June 4th, 2024. So we haven't bothered him at all. But if that has changed, but I heard what the state said, it's
Okay.
information on witness
We
list.
can discuss that aspect of him at the bench or something like that. I don't want to put personal information about anybody out.
No, I agree. Is that something we need to come up now and discuss?
We can.
Okay, let's do that.
All right, they are going to discuss private matter. I don't know. Let's see. Let's go back a little bit because it kind of.
The last week, I just want you to know if it matters to the court. Hold on, can I ask this question? We were told that he's very ill. That's what I was told.
Who?
He is still in
The same
Same
place he
location.
was. Okay. Provide updated.
So the last time before last that we spoke with him,
The names must be named.
I don't have any.
Zachary?
Okay.
Okay,
Can you
Zachary, okay.
provide, if his contact information has changed
Gotcha.
since y'all
Okay.
last provided it to the defense?
All right, we're gonna TiVo real quick. So Zachary is ill, and I'm assuming they want him to be a witness as well. All right. So in the meantime, between time, they're going to talk about that. Let's look at the comments real quick, man. I know y'all been lighting it up, man. Oh man, let's see. Oh yeah, that. Too True says so. The judge is not going to reprimand the state for being late. Exactly, man. Exactly. Look, even Abundance says so. Nothing about them being late. Get Whitaker off this case as well. It says great. Thanks, Judge, for helping the state out again. Another time. Man, it's crazy. Oh, she said, oh, I'm frustrated. Calm down, Jen C. It's all good. It's gonna be all good. It's gonna be all good, Jen C. It's gonna be all good. It's gonna be all good. EKPM LLC says this judge, I know, right? This judge is crazy. It's crazy. Risa says this is ridiculous. Mistrial. Prosecutorial misconduct. Brady violation. I mean, it go wasting time. Dragging out your case in chief. This is, I mean, all this kind of stuff is just absolutely ridiculous. Hot Wayne said, I want justice. This is a mistrial. Absolutely. Breaking it down with B says this trial is a hot mess and needs to end. I'm tired of Judge Giggles. The judge always laughing and giggling and sniggling, and nothing is funny for real. Too True says so. Don't we have to verify this dude's employment of 20 years or just take his word? Car dealers are usually liars. That's exactly. They try to sell you cars. They have to embellish the truth a lot. You know what's so funny about this whole thing with the vehicle? There were witnesses in this trial that testified that, and I'm talking about the witnesses that were actually there and got shot at the barbershop. They got on the witness stand. Two of them in particular said that the shooting came from a white Bonneville. Both of them said the same thing at different times. No, it was a Bonneville. It wasn't an Infinity? No, it was a Bonneville. Now, even the video that the state has implemented as evidence, in that video, Did you ever see anybody hanging out the Infinity vehicle actually shooting, or as they approach, were they shooting? Like, I did not see any of that. I've been watching this trial for a long time. I did not see that in that video. D Pill, shout out to D Pill in the building.
So
Said
with
no
regard
trial was
to
present.
Mr.
They can't reach the
Zachary,
trial.
on the kind of
Facts.
detailed witness list that starts with Copeland at 81, all you have listed for him is the 2 interviews. On this other thing that we all got several weeks back, that just kind of had the order of witnesses. You also had social media and jail calls. Is that something we need to sort through? Or do you not intend to use those anymore?
Tend to use them. We did provide the social media postings that he has.
Okay, that's in that other Dropbox, right? Okay, so let's go to that then, and sort out whether there are any evidentiary issues with regard to all of the things you think you might use evidence-wise with Mr. Zachary.
On the 8th of August.
Yeah.
We put all of this in there.
Zachary folder. So we've got a group of social media, and then we have a couple of, well, I mean, we probably should just make sure while we're here in this folder that there's not going to be an issue about any of the rest of it either. But let's all open up the social media folder first and voice any objections to any of what is in that folder so that I can take those up. I mean, I can see, everybody can see them, right? As long as we are looking at the same thing. Which if we're all looking at the same folder, we ought to be looking at the same thing. And like presumably everybody has already looked at all of this because y'all have had it for a couple of, week, 10 days, 2 weeks, something like that. So are there any objections to any of these social media postings and screenshots?
Just as a general objection, Your Honor, it's not a huge deal with this first photo, but the way we've been doing it is any non-testifying witness, if they've made comments on social media, and I'm not talking about the poster, but just other people, we've been redacting that. Again, it's not a huge deal in this case. Someone named no one trusted says where you at, but
Right.
generally moving forward with all the social media, we're gonna we're going to ask that the state redact anything that's not said by a testifying witness.
All right, and I mean, if there is some reason why that's relevant, you can bring it up, but otherwise, I think that's a reasonable way to go about it. So that's how y'all will operate.
Yes.
Okay. All right, so beyond just that clarification, are there any issues with regard to the things in this folder? There are 23 different items in the folder. And like y'all ought to be ready to go with this, because all week last week I said this is what we're going to be doing. So I can't tell whether y'all aren't saying anything because no, you don't have any objections, or because you're furiously scrambling to look right now for the first time, which should not be the case. Okay. It is.
Let me guess, the state is not prepared again? Are we shocked at this point? Kenzie says she's really telling the defense that, oh my gosh, exactly. That's what I was thinking. I stepped away, but I can still hear.
Defense counsel,
What?
we're not going to be able to take this amount of time before every, sub piece of evidence, because we have, as y'all know, a lot to get through.
I know she's not trying to rush the defense to do anything when they've been getting late discovery since 2022. Cut it out, Judge. Cut it out. Take y'all time. Shoot, the state does. I think Brian's still gonna crack on this judge too in a minute. It's the same way he liked Judge Glanville at first, and then Glanville turned, and she got one more sarcastic statement, and I think he's still gonna let her have it. He's been calling her honorable court and giving her all the, because he know her, right? He endorsed her, he know her. and all that kind of stuff. But I'm telling you, he endorsed her. He did the re-election party for her, all that kind of stuff in April of this year, earlier this year in April. But man, I don't know the way she's going in that Glenville direction. And you know what happens when you go in that direction? And at some point, Brian's still gonna be like, "Yo, what is going on with you? Like you crooked too?" Yep, absolutely. Look at her demeanor. Look at her demeanor. Look at the judge's demeanor.
We, as a group, our stance is a lot of these are just social media posts that do not touch upon any allegations. And we're just essentially most of these cumulative irrelevance 403. And so I know that Your Honor maybe didn't want to do it this way, but if we could maybe just put them on the screen and litigate one by one, I think that might be easier because there's several that are objected to.
Okay, so which ones are objected to, and we'll put those, we can all look at those.
Two,
That's 2015-57, that one? Is that what you mean? When you say two, you mean the second one in there, right?
the second one.
Okay,
Yes.
all right, and assuming the comments aren't there, this is for all of these, unless you tell me differently, this is a relevance and cumulative objection?
It's a relevance objection on this one in particular. From what I can see, it's a video. It's very dark, but I presume it's Lil D. I don't know that for a fact.
Okay, that's fine.
Yelling about Club Crucial and cussing.
Judge, this video. If the objection is relevance. So if the court was able to hear what was being said, this was a public declaration by a YSL member on his social media page that it is Big Brucial. They're at Big Brucial, which is Club Crucial. The substitution of the C in crucial for the B is evidence of what our gang experts have testified to regarding what blood gang members typically tend to do. Mr. Zachary is referencing not only himself, but slime takeover at Big Brucial, YSL. They're using YSL jargon. It is evidence of the existence of the enterprise, the existence of the nature of the enterprise, the associations within the enterprise, and the gang itself.
Okay.
Oh my
Your Honor,
God.
We've
Oh my
beaten the dead
God,
horse
bro.
of B's replacing C's a long time ago in this case. The state has played numerous videos of young men like 13, 14 years old hanging out in a parking lot.
Put Big Bruce in the chat,
saying
y'all.
B instead of C. And I mean, at some point, this is just
Okay.
like we've talked about this.
All right. So is the point of this that it is from Mr. Zachary himself, and it is relevant to his credibility as to whether you tell me,
So
why is it not cumulative?
It's not cumulative, one, because no one, I think in here is going to concede or stipulate that YSL is a criminal street gang. So one, the associations that, and the substitutions that Mr. Zachary, who is an associate and a member of YSL, uses that tie himself and YSL to criminal street gang activity and criminal street gang customs is relevant in
Okay.
itself. Mr. Zachary is an associate and a member of YSL who is testifying. The fact, unless they're going to stipulate to these things, to the fact that YSL is an enterprise and that this is the nature of the of their behavior, of their actions, then none of this is cumulative when Mr. Zachary hasn't testified. And the jury hasn't heard from this witness.
Okay. All right. I think that it is probative to show, on the issue of his credibility and what he may know about the gang, because I assume that there might be some argument, oh, well, this is part of his plea deal and this is something that occurred prior to any of that arguably shows his connection. Now, if the next, 22 all do the same thing, then we'll have a cumulative issue. But this is the first thing from Mr. Zachary that's not, him sitting on the stand saying it. It shows. So
He didn't enter a plea. He's not listed on the
okay.
indictment.
All right. So I'm going to overrule those objections.
Oh my
What's
God.
the next item that y'all
Oh
have?
my God.
Three, relevance.
Okay.
Yeah, she love bombed us in the beginning for sure.
Let me-
You were right about that, Red Bunny. She love bombed us, man. This lady
What's
crazy.
the relevance?
Judge, in number 3, I'd point out that Mr. Zachary's
That's what it is.
social media name is YSL_Lil D. He is in the picture with Shannon Stillwell. I believe that's Demekion Garlington in the back seat. Mr. Stillwell is throwing up the YSL sign. And what Mr. Zachary says in the post that is made on May 5th, 2015, all my dogs dirty, check for mains. I mean, I think it's self-explanatory, but the association, the nature of the,
I'd ask the state to explain what they think that means, because
It's not self-explanatory to me.
okay,
I mean, all my dogs dirty might be, but check for mains.
well, that part, the check, like, check, what, all my dogs dirty, I mean, check for mains, like mains. The all my dogs being dirty is a declaration by Mr. Zachary. And we would argue that it relates to him, his friends, his cohorts, YSL members. Mr. Stillwell seated next to him, Mr. Zachary, Mr. Garlington seated behind him. It is an assertion of who they are and how he perceives them as a group. He is associating himself with them. He's saying they dirty.
Okay, well, so the check for mains part remains unexplained, but
I don't know why Mr. Zachary proclaiming all my dogs dirty would have anything to do with this case.
yeah, well, I
Wait,
mean,
seriously.
it might make something more probative more likely than it would be without.
Is
So
she
I'm gonna
serious?
overrule that. It may or may not mean what she asserts it
Okay.
to mean too. but
Okay.
That's for
This
y'all to
judge,
argue.
Sheely,
Okay,
you
what-
right.
Which one's next?
This judge is gonna let everything
Fine.
in because she is not caught up.
Relevance.
That's all it is.
And I'll just point out that we have
That's all it is.
already through
She's not
3
caught
and
up.
4
She's gonna let everything in.
and 1 and 2 established that YSL
Stick it
Lil
this
D
way.
is his handle at this
Okay.
point.
Yeah, so we don't need it for that anymore, but here we've got stack of money and a firearm.
I don't.
He said 5.
I'm sorry, 4. I'm sorry.
Okay, well, I'm looking at number 5. So let me get back to number 4. All right. State. All right, 4's out.
Man, this judge is just out of her
Is 5
mind, man.
next, or what's the next one?
I don't, unless someone else on the team or on the defense speaks up, I'm okay with 5.
Okay. So what's our next one we have objection to?
Number 6, there's no objection, assuming the proper redactions are made. Number 7, no objection. Number 8, irrelevant, and also, so 401 and 403.
All right, let's look at number 8. All right, they're not going to use 8. I want y'all a little more ready to go tomorrow, okay? I feel like we're looking at them right now and making the determination, and that was supposed to be done before now.
Number 9, same objection. Well, relevance.
Response. And also, to the extent y'all can get together and agree like you did for a couple of the statements, that would save court time as well. Okay, see, this is 3 already that y'all objected. They said, yep, okay, we won't use that. So if y'all get together, maybe we can do more of that. What's next?
This judge irritates my soul, I promise you.
Relevance.
Oh, I can't stand
401
no
and 403.
condescending chick, man. Oh. Oh. She is too nice nasty for me, man.
It is the association with not just Mr. Stillwell. Here it is the witness in the elevator with Mr. Or in the photograph rather with Mr. Williams. And I believe it was Oakland standing in front of them. And this was posted January 2nd, 2015, 8 days before the Donovan Thomas murder. And the caption is at Woody 372 at SB _ living lovely at Thugger 1 a heart and the green snake emoji for the YSL gang. So our argument is that this shows an association.
All right, I'm going to allow that over objection. And I've run the 403 analysis and overruled that. What's next?
This appears to be actually my client's post.
I don't know which number we're looking at.
11,
Hmm.
where he's, I'm presuming, standing next to a gentleman that goes by Trouble, who I believe is deceased now and is, oh, okay, it's a different Trouble, I'm sorry. He is not deceased, but I don't know, his name has never come up in this case at all.
Okay.
So I don't know what the relevance of that would be.
Relevance? Okay.
Number 12, I'm going to acknowledge that it shows Mr. Kendricks in the photo, which if they're going to argue association, that's fine, but this association is being established through 12. So I don't object, but
Understood. If the next 5 do the same thing, it'll be different. All right, so
and number 13 is relevance 403 as well. All it's doing is showing Mr. Stillwell, Mr. Zachary, and Mr. Garlington in a photo together. And this has already been, association's already been established, I think in picture number 3, maybe.
So, Your Honor, understanding that the defense feels that one picture is sufficient to establish a photo, and at some point maybe past one is cumulative, but this particular picture has a caption on it, the date of it being 2/17/2015, from top to the pen to the grave, wherever life takes us. Y'all gonna forever be my little bros at 30DD at YSL little D. Y'all go and follow them, by the way. So, Your Honor, our argument would be that the caption itself is relevant and the date of the association.
I would think highly relevant. I'm gonna overrule the 401 and 403 objections.
Lopsided case, y'all.
What's next?
Number 14 is a post by YSL Buck. That individual, to my knowledge, has not come up in this case at all.
Yes.
So I'm,
All right.
oh, is that Buck?
Yes, it is. Okay. All right, so are you,
I don't know what the relevance is. Buck's not charged. He's not testifying. He was mentioned in a incident from 2013. So I'm not certain what the relevance is of showing a picture of Buck or a video of Buck holding what appears to be a firearm.
Real big bullets, bitch. We ain't play with her. Yeah, huh? That's how the boy bills them. Fuck they doing. So that's how the boy bills them. My motherfucking big bro Snake.
If you hit play, the first person you see as they're talking about YSL, Big B, little bitch, is Quindarius Zachary. So that's further evidence with the gun. It's further evidence of the association and the nature of the enterprise and the nature of the association. One more.
GNC done tapped out on us, y'all.
Also,
She said she can't take no more. I understand.
Underneath at the bottom, you see the hashtag YSL Real Slime with the snake emoji. This is this outward display of aggression, this outward display of, firearms. We would argue go to proof of the nature of the enterprise, the nature of the association, the nature of the gang itself, and the nature of the activities within the gang.
all right,
Your Honor.
yes.
I mean, we've been hearing that explanation for months now. The nature. We're talking about videos posted on the internet by someone who's not charged, that has in the video someone else who's not charged, who's cussing and pointing guns, and I think they say YSL in the video, that at this point, any probative value derived from playing this video at this point in this trial, after all the other videos that have been played, is marginal at best, and it's outweighed by confusion of the issues, prejudicial effect, and the like. I mean, it's just overkill, and all these videos. I'm not going to say all of them, but a great number of these videos have absolutely nothing to do with the issues involved in this case, and this is why this case is taking so long.
Well, I mean, I think it is probative of the assertion that YSL is a gang willing to commit criminal acts. Now, how many, so this is Zachary, Buck, and who was the third person? Do we know?
Not off the top of my
Okay.
head, Your Honor, but I wanted,
Buck is asserted to be an unindicted co-conspirator?
yes, and to be clear, Buck has, not only has his name come up multiple times, he has been in video, he is, his voice was played over a jail call. He recorded one of the videos with Trontavia Stevens and Mr. Williams. So yes, these two are YSL Associates members. And also, just as to the point that Mr. Sharp made about the number of videos, the constant cross-examination and sort of rebuttal against this idea that it shows an association, and the nature of the gang is that it's promotional, it's music, it's art, it's something that's not related to criminal street gang activity. So our position on that is unless there's this stipulation regarding that, which we assert that it's relevant to prove, that every time that they argue that a particular video is promotional or it shouldn't be taken literally, they are creating the need for the state to show the jury evidence otherwise.
Okay, do we have a video similar to this one in already?
No.
Do we want to dispute that and point me to what is?
When you say similar, I mean, the state played.
I mean,
think
not like a music video,
the
but
state played. I believe twice they actually played it. About 13-minute video of young men talking about YSL and slime in a parking lot outside apartments.
are they pointing guns at the camera while threatening to do things in the name of YSL?
I'm being told that guns were pointed in that video.
And is it I don't mean a music video.
No, it's not a music video. It's a video of.
And who are the people?
It was Walter. It was Trontavia Stevens, Lil D, Mr. Williams, Walter Murphy.
But not Buck or Zachary?
Lil D, what was that? Okay, so Zachary, I'm being told, was in it. Buck was not in it. I don't know what is important about Buck,
All
quite
right.
honestly.
If y'all want to tell me exactly what, exhibit number that is, or give me that to look at, but my inclination is that this sounds different enough in not cumulative. So I can look at it and, I may change my mind, but at this point I'm overruling the 401 and 403 objections.
We'll get you that exhibit
Okay.
number. 15 is my client's undated Instagram post showing a picture of Mr. Zachary. I believe that's Mr. Zachary, although it doesn't quite look like him. I believe that's him. And he's standing next to a platter of pastries.
So I think that's a relevant subjection.
And cumulative, because the association has been shown.
Okay, what does the state say about that?
Judge, we don't have to use this initially. We believe that it could rebut a particular line of cross-examination, but right now we won't use it in our direct of Mr. Zachary.
Okay, so there may be some cross-examination about whether they went to a bakery one day and then this might be relevant. Otherwise, they're not going to use it.
And Your Honor,
I'm kidding. I mean, it may be relevant to something else, but who knows? I don't know.
it's Mr. Stillwell's post
Right.
of Mr. Zachary, and his commentary about Mr. Zachary is what we were looking at that was
All right.
most relevant.
He's commenting my dripping. So he's commenting on his clothes.
He's dripping in blood. There's a red jacket that he has on, and that jacket, our argument is that that's what he is referring to.
Okay, well, at this point in time, we're not going to be using that one.
Okay.
What's next?
16 is fine, no objection.
Okay.
Yes. 17 is fine, no objection. 18, 401, 403, the association with my client has already been shown. Not sure, that's Your Honor, just so you know, that is Mr. Zachary and Mr. Stillwell seated behind a bottle of liquor with large amount of cash on them.
So, Judge, this is part of our indictment talks about the purpose, and hang on, I'm going to just read the language. Obtaining money as associates of Young Slime Life, the defendants conspired to associate together for the purpose with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity, including robbery, theft, and the unlawful sale of and distribution of drugs.
Mm-hmm.
This is Mr. Zachary posting large sums of money with Mr. Stillwell and asserting their unity. One thing about my brew, again, the B replacing the C, we all eating. So he's talking about,
Yeah, we're rolling in the day. We're doing well. Do we have other things that already show this that are similar?
Yeah, which I just admitted earlier. The
No,
B's
I
placing
don't
the C.
actually think there was a cumulative argument on this one. It was relevance in 403. Overruled. What's next?
Dang, she's just letting everything in.
Number 19 is
number 19. Is that the next one?
You hear that? Is that number 19? Is that the next one? They don't even know what they look. They don't even know what they're looking at, man.
And
I heard
who
the
all do we
state.
have depicted in this photograph?
Oh my goodness.
We believe that this is Mr. Zachary, Mr. Nichols, and the third person we're not certain about.
All right, this is showing Zachary and Nichols in the same kind of YSL posts with guns.
Showing, yes.
Okay.
Your Honor, 403.
So,
Highly prejudicial, outweighs the probative value.
it does not. Overruled. What's next?
Well, damn.
Okay.
That is who is shown in this photograph.
Okay.
So at the rate of this, you could almost tell that she's going to deny that motion from Weinstein. I'm pretty sure that motion is going to get denied for sure.
23 is another
This is crazy.
picture of Mr. Zachary and my client, Mr. Stillwell, at some sort of arcade, sticking up their middle fingers. I would object to that. Relevance 403.
All right.
Cumulative.
Days,
Go ahead. What's the state's response?
6 days after the murder of Donovan Thomas, this post is made. We gangster in every city we go.
That does.
This is 23, right?
25. Oh,
20. Which
yes,
one is
number
this?
23.
20, yeah, okay, right.
You can't always go off when a picture was posted, because some pictures are posted, but they were taken either days, weeks, or months ago, or whatever. Every post is not the same day somebody taking a picture. There's a lot of people that go on vacation and they post their vacation pics
Okay,
after they
main
come back from
objection
vacation.
is,
You can't just
403
utilize
on this
that.
one.
And relevance.
Gotta
And
get the
Your Honor,
metadata.
while we're at it, the state said, brought up the caption. I don't know why that caption would be displayed. That's the words of Lil D. Sure, he's testifying. I guess potentially that could be impeachment, but I don't know why his out of court social media declaration would automatically be admissible.
It is the assertion, the public assertion, the fact that it is made publicly to display their dominance. This is 6 days again after Donovan Thomas. We believe that they
See?
went out of town into another city following the murder of Donovan Thomas, and an assertion that we are gangster in every city that we go. The fact that you
Red Bunny,
made
you
the
feel me?
post, that you put yourself out there with another YSL member in itself is evidence beyond the words that are spoken.
What rule of evidence would allow an out of court declaration by someone who's is not a statement of a defendant or a statement of a party opponent? I don't know what rule of evidence. They keep saying because he's saying they're gangsters.
I
Okay, but
assume, is he alleged to be an unindicted co-conspirator? I would think that would be the rule of evidence.
I don't know how this would be deemed in furtherance of a conspiracy.
Because it shows, number one, it asserts their dominance. It shows it asserts their cohesiveness. We are gangster in every city we go. It promotes their
Man, that's just talk. Oh my God, man. Prosecution suck. Look at Hilton and Love. They can't get it together. They can't get it together.
it preserves and enhances and protects their reputation, power, and territory by the posting of messages, images, videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf. It is literally a line that I just read is literally a line from the indictment. And so this post itself is proof of that assertion and allegation in our indictment.
All right, I'm gonna hold my ruling on that, and we'll see what else.
No, sustain it, Judge.
Your Honor.
Oh, you want to
Yes.
hold your ruling on that.
We're going through, there has to be some sort of foundation. I mean,
Yeah.
if Mr. Zachary says, yes, I posted something like that, then that would be bolstering, right? It would just, or cumulative. If he says, yeah, I posted that, and this is the reason why, just because it's in the indictment does not make that assertion credible. So the witness has to testify to all this before it just comes in as an exhibit. Am I wrong?
Well,
I mean,
it has
that's
to
what
get
I will be
introduced
objecting.
in some form or fashion.
It has to be introduced. That part we agree, but not that it's not permissible or admissible as an item of evidence just because he says I did post it.
Right. Okay, so I'll withhold ruling on that one. What's next?
She gonna let it in.
That's all the social media in
Okay.
this folder.
All right, so
Oh, yes. What's the exhibit number? And Your Honor,
yes.
the exhibit number for that other video that's already been played states 16. Oh, I'm sorry, 60 WA.
Okay. If y'all have it handy and can just shoot it to Ms. Bursfield and I don't have to go through the former court reporter to find it, that would be great. If not, I'll try it the other way. All right, so let's look and see what else is in the folder.
Social
for
media is
Mr.
not evidence, man.
Zachary. There's, well, y'all can see the same things that I can see. Is there any
Not hard
objection to
evidence
the
like
other
that.
5 items? I think one of them's the last one's one of the interviews. So is there any objection to the other 4 items?
The second to last one,
Yeah, I couldn't open that one.
I couldn't
actually.
either.
So can y'all maybe share that one? Do y'all know the one we're talking about? I don't know. It may be. It's 3.95 gigabytes. So maybe. It just seems to be in a format that. Okay, so it's the other interview. Okay, that's fine. All right, so then objection to the other 3 items.
Yeah, providing that the jurors are still interested in this case, yes, I don't think they will see social media as proof of anything. I mean, yeah, it shows them together, but that's it. It just shows their association.
Anybody?
It doesn't prove anything. Social media is not, you can't use social media post dates
Okay, and you're speaking
to say
for, I
that this
guess,
picture was
everybody
taken
else's
on that day. That's
silence
just
is
when it was
assent
posted.
here. Okay. All
Let me
right,
be quiet
so
now.
that's
I'm going back on mute.
Mr. Zachary. Should we look at, is Mr. Sledge, let's look at Mr. Sledge. He's going to be either right before or right after Mr. Zachary. Okay, let's see what's in his folder. All right, we've got a jail call folder, a social media folder, a tattoos folder, and then some other items.
Did she say a
Have we already
tattoo
dealt
folder?
with any jail calls for him?
Your Honor, that's the one that the state said they would only play.
Yeah, I'm trying,
for
man.
impeachment.
Red Bunny feeling me right
Okay.
now, yo.
And that's the only thing in
I'm
that.
getting
Yes,
upset
okay.
for real, man.
So that's all right. And then how about
Oh.
social media? Do we need to go through his social media? I would suspect.
They got
Yes, Your Honor.
tattoos as
Okay.
evidence, okay? She said tattoo folder. What the what,
Yes,
what is going on now?
yes. If anybody else needs to use the restroom, all right, let's take a quick convenience break.
Yes. Yes. This is absolutely unhinged. I heard tattoo folder. I heard tattoo folder. They're gonna submit tattoos as evidence. Okay, so this judge is just letting anything come in right now. And again, I think it's because of the fact that, excuse me, she's not caught up. She's not caught up. And I think she just want to put stuff in there so she can catch up. She's not caught up for real. She not the same thing that she's asking everybody else to do. Y'all talk to each other and y'all make sure that y'all get together and get all the things you need to get together with about. And you haven't done what you're supposed to do. You haven't done what you're supposed to do. You're letting all this stuff in because you are trying to catch up to a trial that started in November, but the case been being built since 2022. Matter of fact, it was so much stuff going on before that. They was trying to build the case when Paul Howard was in office, and Paul Howard was like, "No, we're not doing the case. We're not doing this case. We don't trust Woody, so we're not doing the case." Paul Howard never went after Young Thug because of this right here. Because of this right here. Like, come on, man. This is absolutely insane. This is overkill. So this social media is the part that irritates me the most, right? Because again, you cannot use social media postings as evidence of the time frame. This is the reason why. Because when you look at a social media picture, you're only getting the real-time posting of it. You're not getting metadata. The metadata shows you the device that you use to take the picture. It shows if the picture was doctored up by Photoshop. It shows the time that the picture was taken. It shows the location that the picture was taken in. It shows the date of the picture being taken. That's at least 5, and it's a lot more metadata information, but that's at least 5 crucial things in metadata when it comes to photos. If you all remember the Amber Heard Johnny Depp trial, and there was an expert who came in who broke down all those photos that Amber Heard put into evidence. All those photos that she put into evidence of her getting hit in the face or whatever the case may be. Come to find out, when the person extracted the metadata from the pictures, that picture was in Photoshop. That chick added some highlights, some warmth, some saturations. She doctored up her own picture to try to frame Johnny Depp as some crazed domestic violent maniac. When come to find out, all the evidence pointed to the fact that she was the one that was abusing him. She the one threw a bottle of vodka at him and he cut half his finger off. He had to get it reattached. She did a William Shatner on the man's bed. She did a Shatner. Okay. When you're going and you're in a trial and you want to use photos, you got to use the photos with the metadata that confirms the date and time of a photo. Oh, this picture was posted 6 days after Donovan Thomas's murder. Okay. When was the picture taken? You won't be able to answer it. They won't be able to answer it. They won't be able to give evidence of when the picture was taken. You know why? Because the prosecution is lazy. Y'all have an expert. I'm sorry, my boy Left Hand. Everybody shout out Left Hand in the chat, but Left Hand irritated me. Y'all got an infinity expert. What does that even look? A car dealer? some person who sold a bunch of cars before. Like, what are you talking about? I don't. What do you mean? We have an infinity expert. You can literally Google a 2015 Infiniti Q50, 40, whatever the model was, and you don't have to be an expert to have eyeballs. And when you look at the video that they submitted as evidence of the drive-by shooting, in that video, you don't see not one person hanging out of a window. Their window is not down. No actual gun is being pointed outside of a window of any point. And this particular gray vehicle that they're calling an Infinity was driving by so fast that when the shooting occurred, it didn't even correlate with the time frame of the passing of the car. Then on top of that, there's no sunroof, right? Thank you, Sheely. No sunroof. Then on top of that, the people who were actually there getting shot at said that it was a white Bonneville that did the shooting. And the prosecution was like, and my man, the light-skinned dude, I forgot his name because everybody was talking about him and everybody was talking about that dude. But he was like, are you sure? Look, it was a white Bonneville. 2 witnesses said the same thing, a white Bonneville. They specifically described the grill of the Bonneville. Everybody knows what a Bonneville looks like. So they said that vehicle was the one that shot at us. And from what angle were the shooting at? That camera was only facing towards oncoming traffic from one particular angle. They had no camera in the actual front of the barbershop. So bringing in an Infinity expert after your witnesses state said white Bonneville. And I could tell, and see, you could tell that the state never prepped any of their witnesses because they was not expecting them to say white Bonneville. That's why they tried to come back and ask more questions like, you said white Bonneville? Or a white, or was it a gray Infinity? No, it was a white Bonneville. I know a Bonneville when I see one. I know a Bonneville when I see a Bonneville. They stated that it was a Bonneville, a white one. Now then, fast forward from their testimony to Woody's testimony last week, he said, I picked up the gray Infinity and gave it the threat. I don't know what he did with that Infinity, but I gave it to him. Okay. But does the video show evidence that anything from the Infinity was showing weapons or any of that? I've seen that video so many times. I did not see not one human being hang out that window. I didn't see a sunroof. I didn't see anything where that vehicle in particular was the culprit of the shooting. All we saw was bullets ricocheting and all this kind of stuff. We did not see someone actually slow down enough. Which, listen, I'm from Detroit, man. I done seen drive-by shootings before. They not coming down no street with headlights on at night. When you see, if you ever lived in the hood and you ever witnessed a drive-by shooting or multiple drive-by shootings, they always creep up the doggone street with no lights on. They don't want you to know they coming, and the car gonna be black. The car is gonna most of the time gonna be black. Why would I come down the street? I'm doing a drive-by and I'm coming down the street in a neon green vehicle. Like what what kind of foolishness is that? If I'm gonna do wrong, I'm gonna do wrong the right way. I'm not gonna do wrong. Oh yeah, they on the busy street, they coming up with headlights on, all this kind of stuff, and next thing you know, pop. You don't see nothing in that video shows anybody hanging out the window shooting a gun. So when you are looking at a drive-by shooting, or if you witness it in real time, they have no lights on for the most part. So you're in the main street and they just drive it. You don't see no gunshots from that vehicle. but you do see shots being ricocheted off of walls, off of cars, or whatever. So what evidence does it show that that vehicle was used for this particular situation, drive-by shooting in particular? How can you show that to be true? Your boy Woody said he gave it a threat. Threat is not here, unfortunately. He is not here. What did Threat do with the vehicle? I don't know what he did with the vehicle. All I know is I gave the vehicle to Threat. I have no idea what he did with it. What are you going to do with that? How are you going to do that? How are you going to say, these are your witnesses, prosecution. This is your witnesses. You got witnesses to say the same thing on different days. That was a white Bonneville. 2. Your star witness says, I gave the Infinity Threat. What did Threat do with the vehicle? I have no idea. All I know is I gave it to him. I know something. He said it off the record in the ex parte. I know something about the Infinity that y'all don't know about. And I know the person you're looking for is not that you're looking for the unaliving of Donovan Thomas is not on this case. They're not in this trial. Hey, Yana, anything I say can't be used against me, right? Right? I gave Threat that vehicle. I gave Threat that. What? Wait, what? So your witnesses that you have on your list, you haven't prepped them. You had 700 people on your list. I know darn well you didn't talk to 700 people and prep them for testimony. I know good and well that you did not talk to 700 witnesses on your list and prep them for testimony. As a matter of fact, you even altered your testimony list, your witness list, and the 400 people that you had on the list you didn't talk to. Then you had to alter it again with the new judge, and the 100 people on your list you have not prepped for no dang on testimony. You have not talked to none of your witnesses that you got on the list for their testimony. That's why when they said the white Bonneville is the one that was doing all the shooting, y'all look dumb. Especially the light-skinned dude, because he thought he was cooking. The light-skinned dude thought he was cooking, right? He was showing like, can you tell me what that Hertz receipt says? And what's the date on that receipt? And when was the return of the vehicle on that receipt? Uh-huh. Okay. Now I'm going to show you another receipt. Who purchased that vehicle? It says Jeffrey Williams. Okay. And what's the date on that receipt? Oh, he thought he was cooking. He thought he was chefing up a masterpiece. He thought he was chefing up a masterpiece. Huh? And then Brian Steele came right after that and said, hey, man, if I come to your establishment with somebody else's ID, can I still rent a vehicle? You know what the regional manager of Hertz said? I don't know. Maybe. You know what? I never thought about that. Fast forward to some more witnesses. Man, they shot us with a white and out of a white Bonneville. Excuse me, sir. What you say? What you say, sir? Oh no, it was a white Bonneville. No, I know a white Bonneville. We was the one getting shot at. We was there. Now, my boy Left Hand, aka Atkins, Left Hand is gonna come in here and say, "Hey, we got an expert about Infinities. He's been an Infinity expert for 20 years." Baloney! Stop playing with me. Stop playing with me.
All right, we're
All right, we
looking
back.
at
I'm
the
done ranting.
social media posts for Mr. Sledge. Which ones do we need to litigate? So for whatever reason, I don't seem to have let me see if I can find the numbers. They were a lot clearer on the last group. So give me a minute to find where number 3 is.
And Judge,
Yeah.
am I incorrect? I believed that we had gone over Mr. Sledge's social media post. We did not?
I don't know if that happened.
I thought that we had gone over them. Some of them at least, and particularly number 3, if that's the one that's labeled State's Exhibit 397Y.
397Y. No, I've never seen that.
Where we talked about the fact that it was the night of Donovan Thomas's murder and that he was
Yes.
posting.
Yeah, I
Patriots
remember
Day?
talking about it.
Okay.
We haven't reviewed this, and my objection to this is the state keeps inserting these January 10th, 2015 captions on these photos.
We don't,
If you look at every other Instagram photo, there's nothing like that. But then on these January 10th, 2015, they're inserted, and that's inappropriate in my estimation. And that's my objection.
Sustained. I don't
Judge-
think y'all need that. That's not what it really looks like.
that's.
She
fine.
sustained an
We do-
objection.
We intend to show evidence that it was posted on January 10th, 2015. So we can take out that little square that's above
The
the.
hover, yeah,
Yes.
okay. All right, so that objection is sustained.
And number 4, the same thing.
Okay, they'll adjust that one as well.
That's right. And so Judge,
Yeah.
as I said the other day regarding the other inquiry about that, as I'm asking the court, if we establish with the witness who caused that to pop out.
Right. I would think that if you are having that witness testify here, here's me looking at the social media and here's what I do to find out the date it's posted and this is what it looks like. Here's, when I hover. I mean, I think that's fine and you can show that, but I think the exhibit that goes out to the jury needs to be just what it looked like, not with the hover.
So if, no objection to that ruling as to showing the exhibit with Mr. Sledge, right? Because he
Right.
wasn't the one that hovered.
Right.
But as to, for instance, ADA Sprinkle, who would have been reviewing it and who would have been hovering, screen grabbing what shows up when he's looking at a social media page is relevant, we would argue, relevant evidence of the date that it was posted that goes beyond the memory of.
All right. What does the defense say to that? Like the proposal at this point is not to have the hover part with these witnesses who posted or whatever, but with the investigator or prosecutor who I guess was in charge of collecting this evidence and who confirmed via hovering that that was the date it was posted.
If my stance, the state keeps saying Mr. Sprinkle did it. I don't know that to be a fact. So if they produce the witness who hovered.
I mean, I think that's their plan, right? Is to put Mr. Sprinkle on the stand and he will testify to that.
Sprinkle, Gaither, Dennis, whichever one, because there are multiple
Okay.
ones.
Well, so that's my whole point.
So
You keep
yeah,
saying
whichever, that will have to come in through whichever witness did the hovering.
That is what we're saying.
Okay. All right. What else?
Number 5 is.
Well, could he just,
I'm going to object to number 5.
which one?
It's
I can't tell what number 5 is. These
On-
aren't labeled the same way as the other ones.
on your top right of your screen. Do you have something that says 5 of 37?
Okay, yes, and they're also labeled. So that's State's Exhibit 399 Yankee. So that's the video. It's 39.
Okay, got it.
So
Do I need to watch the video? Because if so, I need to pick which media player
I
I'm
can,
gonna.
you can just, I can hit it. It's a regular one.
Well, I'm not on Zoom, so do I just need to
Oh,
hear it?
I think
I
hearing
can
it-
join Zoom, but I just hadn't yet. So give me just a second.
Yes, Your Honor.
Do I need to see it or just hear it?
I think hearing it would suffice.
Okay.
That's.
Keith, do you want to?
To fill the screen.
Kids, you lied to your mama,
I just forwarded.
but you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
I didn't stop it. Let me try it again. It's loading. Oh, Lord.
Lie to your kids, you lie to your mama, but you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
So
I thought we did discuss this one already.
There was a prior video that's been admitted into evidence where this is my recollection, and Ms. Williams, if this is not correct, I apologize. Mr. Williams, we discussed this one as well?
We did.
Okay.
We did. Okay, so on to the next one we didn't discuss.
And though my next one I had object to is number 11.
Okay, can y'all tell me what state's exhibit number that is?
yes.
And number 11 is, it's State's Exhibit 406Y. And to me, it seems to be a collage of other photos with Mr. Sledge and other individuals that show up in other exhibits. There's no new associations that are revealed by
Okay.
State's Exhibit 11.
All right, is the point of this one the post that goes along with it?
Yes, Your Honor. Just 1 second. We're pulling it up. You got it. Yes. Just to put on the record what it says. I love my slimes, well, snakes, and they green heart emoji me. And it's a photo grid of Mr. Sledge and other YSL members. So yes, the post and the association and the public proclamation of that association.
All right, so similar to when Mr. Zachary is himself saying, yeah, these are my YSL people and here's me with them. If we don't already have something, I mean, we may have these individual pictures, but we don't have this assertion yet by Mr. Sledge, then that is not cumulative. So that's admitted over that objection.
Number 13 has a similar caption.
What's our exhibit number for that one?
408Y.
Okay, thank you.
Has a similar caption, and it seems to be my client dancing.
Okay, so that one's a video, which I can't open. And I don't know why, even though I'm now on Zoom, I can see it on Miss Persifield's, but I can't see it on mine.
Ms. Hilton, if you could share via Zoom, that would be helpful.
Oh, there it is. Okay, I got it now. There. Are you gonna hit play?
Share the same.
This is yours. Okay, all right. Okay. Is there anything added to this one that isn't captured in the still other than a good beat?
You just created a soundbite.
Y'all playing, man.
The still showing all of the members of YSL and the post are the most pertinent parts.
All right, so then y'all don't really need this one, right? I'm asking, is there,
We don't need the
we
video.
just looked at number, was it 11? That was like the collage. Are there people in this still or part of this video that aren't also in that collage?
Mr. Williams, I believe, but I'm checking to see in the
Okay.
collage whether Mr. Williams
All
is in
right.
the collage. Mr. Is he? You can't see his face in the collage. So the still shot is in the collage from the video in the upper left-hand corner, but
Okay.
Mr. Williams' head is turned away from the
Okay, so
camera
if you
in the
want to
video.
capture a still from that video that shows Mr. Williams, then you can use it.
Okay.
Okay.
And this is not considered cumulative,
Next.
dog. Jeez, oh Pete.
14 is the same thing.
14 is which exhibit number? 410Y or
09Y. I'm sorry.
409Y? I thought that's what we were just looking at. Oh, well, no, that's a different one. Okay, that seems cumulative. Unless there's some reason that the state believes it's not.
These are different people, and this is, can you hit play? This is Mr. Sledge, Trontavious Stevens right there, and Mr. Williams' sister, and showing the association, as showing
Bring it on the big.
again when they're talking about I love my green heart, green snake, red hearts, emojis. We have jail calls that we have asserted are co-conspirator statements that involve Mr. Williams' sister.
Okay.
All of these same people are in.
I don't know that the sister is the sister.
There's another exhibit, 405Y. The state, this is an unrelated trip to the club, and now we have 2 videos, a collage, and I think 2 photos
Okay, so
documenting this night at the club.
okay, so which videos are, because I haven't, unless there's some video that you just didn't.
Well, I didn't object to it.
Okay.
It's 405Y is a picture of everyone.
To prove what exactly? That they all know each other?
Okay, and does that show the sister?
We all know each other. Seriously. Yes. Yes.
Does the state know whether the photo that's a big group shows Mr. Williams' sister?
Okay, 2 things. So I don't know that it's the same night as Mr. Sharps argued, but
Well, I'm
I'm
not sure
looking at
that's
the-
relevant. If the point of it is to show their association, then whether it's the same night or not.
Okay.
Does this show Mr. Williams' sister with this, general crowd of people?
Okay, we're going back to 405, was it?
Yes.
This one? He says States Exhibit 405.
It's picture number 10.
Okay. Can you go down?
Okay, well then, that video then shows something that's not shown already. So that video is number 14. So that's admitted over objection.
Oh my God.
What's the next?
410Y, it's some sort of meme that was shared by apparently Mr. Sledge. Makes no reference to anyone in this case.
So, Your Honor, the reason that this meme, we would argue, is relevant. You're about to get 20 years for a crime your best friend did last night. Do you snitch or take the beef? You tell the punk ass police to do their fucking job. So Mr. Sledge, in his interview, he essentially said as much. On his video that the court heard a moment ago, he intimated as much. But what he's doing in this particular posting is making a public proclamation displaying their belief towards snitching. You have not only Mr. Sledge making that lie to their mama, lie to their sister, get into court and tell the guys on his truth. You have Mr. Williams, who posted a similar video with Mr. Sledge apparently in the background, mumbling, saying, sort of signing on to whatever it was that Mr. Williams was saying at the time. We would argue this right here is more of that, this is who we are. You know, we don't snitch. You let the police do what they're supposed to do, but you don't tell on your friends. And under the circumstances of this trial, especially considering some of the testimony the jury has heard, we believe that this particular type of posting, public posting, is very relevant
You
to
gotta be
explain
kidding me.
some of what the jury has seen.
Okay.
You gotta be kidding me.
Yes.
First, the state has said they have a video of Mr. Williams saying things about snitching and Mr. Sledge saying things about snitching. So this is cumulative. Also, you know, the state keeps saying they feel this, they're saying this. Mr. Sledge owns and operates, presumably, his own Instagram account. At no point does he make any reference to anyone involved in this case. At no point is he saying he's speaking for YSL. At no point is he hashtagging YSL or at YSL, anything. He's making a comment as an individual on his individual page. And he's really sharing a meme, but I don't know why that's relevant. And it's certainly cumulative when the state just said they have other people. They have him actually giving a statement, and they have Mr. Williams giving a statement that's already in evidence.
All right.
This particular assertion, it doesn't just say no snitching. It says you're about to get 20 years for a crime your best friend did last
It's
night.
a
So the
meme,
fact
Miss
that
Love.
Mr. Williams has made an assertion that is very similar in nature to the one that Mr. Sledge has made. And then the fact that this particular posting references not just telling on someone, but you're about to take the heat for something your friends did. It's displaying yet another message to the public about YSL and we would argue, their willingness to stick together and stand on, you know, their loyalty towards one another. The argument, I don't know that it's so much necessary to say that it's, you know, it would be our argument that he is asserting the sensibility, the way that YSL operates. That's what we would be doing. It's proof. We would argue it's our evidence of the way that YSL sort of.
All right. I'm going to
promotes
sustain
itself.
that objection on 4
Thank you.
grounds.
Please sustain that. I was about to say, you let that in, you on some bull for real. Woo! She let that slide. Thank you, God, because that was crazy.
Why
That was insane.
is this the same video that was was, I believe, 399 and 413 are the same. Am I incorrect?
I don't know. Are those the same video?
Oh, I'm sorry, it's a different video, but he's saying the same thing. He says the same thing twice about snitching and things of that nature.
So do I need to hear what this says?
Hey man, nigga getting to tell lies to his kids, tell lies to his mama, but get in the courtroom and tell the judge the God on the truth. Y'all pussy ass niggas, we call you whole ass niggas strip now. Fat hoes.
So I think it's actually, and I think it's the same words. One time he's wearing a white t-shirt, it appears, and one time he's wearing a white tank top. I don't know why he recorded it twice.
We can just use this one, especially since he says black at the end.
Okay.
BLATT, black.
All right. So this one, and what's the number that you're not going to use instead?
399Y.
399Y will be out then. Okay.
And Your Honor, the other issue is that posting it multiple times, posting their feelings about snitching multiple times, it is meant to reinforce how strongly they feel about it.
All right.
Oh my
so
God.
What were the dates of the two posts? I had understood you to say that you wouldn't use the other one, but are you now saying you do want to use the other one?
So we would ask, yes, to use both because if one is on July 19th, 2015, and the other one is on 399 is on July 19th, 2015. And the other one is on March 25th, 2015. We would ask to be able to use both.
Okay. Well, I mean, that does show that this isn't a one-time thing. I guess at least this guy wants to reiterate it. So I will admit that then. What's next?
416Y. Relevance.
What's the relevance of this?
Get it now.
So who all's in that?
Martinez Arnold, Diamante Kendrick.
I mean, I can see the relevance. What I'm wondering is whether it's cumulative. But Arnold and Kendrick, I don't think we've had any, at least in what we've reviewed so far, the two of them.
They've both pled together on a count in this indictment. I mean, there's going to be absolutely no. No, not on this indictment, but there's a count in this indictment,
Right.
and an overact where they both pled.
Yeah. No,
So-
yeah, no, I'm saying we don't have any videos or photos that we've at least looked at today that have the two of them wearing YSL garb together, right?
I don't think we have.
Okay, well,
We have. Not so far.
okay. Anybody dispute that?
I don't believe so.
Okay, then that will be admitted over objection. What's next?
Number 22. It's another video that I don't see the relevance.
Okay,
417Y.
Thank you.
Bitch, we out doing a little shopping, bitch. How we having this shit?
We gonna make folk be pumped. Hey, tell them I said we can go back and forth, man. We doing a lot of little shopping. Man, you know, fucking up Scott. Chinchilla in the shop.
Yeah, turn up.
So that was the extent of that. Was the court able to see it?
I mean, tell me who all's in it and
It's
why
Miss-
it's.
Shannon Stillwell, Diamante Kendrick, Antonio Sledge.
Mhm.
And this is a couple of months after Mr. Thomas's murder. Diamante Kendrick is in the coat that he is wearing the night of Mr. Thomas's murder. And they are still very much associating with one another. One of the arguments that was made the other day by, I believe, Mr. Sharp was he objected to part of the factual acknowledgement of Mr. Sledge and argued that he would have had no basis for personal knowledge of information that had happened on a particular night.
Okay, well, this might show that as a foundation, but that's not for the jury, that's for me. So,
No, I'm just, as far as relevance goes, it would be relevant for those purposes.
We've just seen.
Co-counsel is emphasizing that jacket being the jacket that he was wearing. Mr. Kendrick, if we need to rewind it, we can show you.
yeah, I saw it.
Excuse me, I don't believe that's the same coat. I believe it's arguably similar, but I don't believe it's the same coat.
How do y'all know what he was wearing that night anyway? What evidence is in or gonna be in?
It's on video. He's clearly walking into a store that's a few 100 feet away from
Okay,
Mr.
and that's clearly him. And so what does it matter that he's wearing the same coat later? It's his coat. I mean, why does that matter?
No, just
I mean, seriously.
in terms of one identification, I understand that the court is saying you can see him clearly on the photograph in the surveillance video, but also he's with Mr. Stillwell, who is also alleged to have committed the act with him 2 months afterwards, and he's with Mr. Sledge. So when Mr. Sledge gets on the stand and tells the jury, or whether he does or doesn't acknowledge that he knows.
All right, well, so then this might come in as impeachment evidence, but I'm not hearing. Like, oh yeah, no, we never hung out, or we didn't hang out after that night because I was appalled at what they supposedly did, then yes, but otherwise.
And also, I think, and Mr. Kendrick filed an alibi notice as well regarding where he was at the time of the murder, so.
Okay, but this has no relevance to his alibi.
Not directly, just that it's further proof that that's him in the video and him at the location and him right there 6 minutes before the murder.
Okay, so then back to the coat being the thing that matters then.
Yes.
I guess if your client, Mr. Weinstein, is saying I wasn't.
He's not denying being
Well,
at the gas station. It's in the video. You can clearly see that he is
Okay,
walking
so
into the gas station.
What's his alibi? Then maybe I'll need to go look up the alibi notice.
He was with Miss Morton later that night.
So it doesn't cover the time of.
No, he was with Miss Morton at the time of the murder.
Okay, what time?
But what the coats have to do with this, I have no idea.
I
And what a
guess
March video has to do with his
it's
alibi
some-
on January the 10th.
Right.
The
so
time he was
what's the time of the gas station video?
at the time, it was at the time of the murder. It was 6 minutes before the murder.
Okay.
Your Honor.
No, hang on just a second. Sorry. And then is Mr. Kendrick's alibi that I may have been at the gas station 6 minutes before, but 4 minutes before, through the time of the murder, I was with somebody else somewhere else?
Correct.
Yeah.
Give me 1 second.
Okay.
Oh my God, dog, this is crazy. This is crazy.
Yeah. Yeah, again, there's no denial that he was at the gas station prior to the murder.
All right, but not, okay, so the coat doesn't add anything to that.
But it's not the same. He's like my wife, Your Honor. He buys the same style coat, but it's not the same.
Whether it's the same coat or a different coat,
Yeah, it's
it
irrelevant.
doesn't show anything about
No.
the viability of his alibi. And anything else before I exclude this one? No. Okay, moving on. That one's out.
23, Your Honor. The previous photos have 418Y have
Okay.
continued to show an association between Mr. Sledge, Mr. Zachary, and Mr. Stillwell. That's been established through the photos already.
All right, and who is this we've got right now?
That is Mr. Stillwell, Mr. Zachary, and Mr. Sledge.
Go ahead.
I would point out the caption that Mr. Sledge makes underneath the photo: gangsters sitting at the round table with 3 green snake emojis on March 4, 2015.
And those same emojis are what justified all these previous.
Okay. So is it, are you making the argument gangsters sitting at the round table is like a reference to King Arthur and the Knights of the Round Table, or what? Or
No.
just the fact that they're saying gangsters?
That they are calling themselves that he is calling
Oh my
them
God, she's
gangsters,
reaching.
because I
She's
believe
reaching.
at some point there will be. We've heard at least one witness while we were talking about gang say game,
Way too much TV.
like GAME. So I believe that there may be efforts to distance YSL members. Well, there have been consistent efforts to distance YSL members from being gang members, gangsters. So we would argue that he is not just sort of making this, oblique reference. He's proclaiming for the public something.
What?
The generic term gangster is propensity, first of all, but secondly, if Mr. Sledge says something on the stand that's vastly is shocking to the state, and they feel that this contradicts it, then perhaps there's another discussion. But in and of itself, until that happens, I don't know why this would be relevant to anything.
So remind me, the one that gangster in every city we go, that would show the same thing.
You didn't keep it in.
I didn't rule it out. I
You
held
didn't.
it.
We would prefer
So-
this one over that one.
All right, then
Wait.
that one will be
Hold-
out and this one will be in then, but they kind of get to the same thing.
So, Your Honor, could the court give me?
Sure.
Okay. If we're going to choose, we would choose the one closer in time to Mr. Donovan Thomas's death. So
Okay.
we would cede this one if
All
the
right,
court.
so then 418Y is out. And if it ends up being some kind of impeachment evidence, just sort of alert us before we use that.
Okay.
Okay. What's next?
Number 421Y, which is number 26. It's another group photo.
Mhm.
This is a picture that's in our indictment. I believe we may have even already admitted the photograph, but the caption is also part of what is important. So both the photograph, the caption, and the fact that it's in our indictment alleged as an overt act.
What do you mean alleged as an overt act?
The posting of that photograph was
The
alleged as
posting
an
is
overt
alleged as an
act.
overt act.
Yes.
Okay. Then, and so, okay, you allege as an overt act that they post things that promote YSL, and you showed this picture as an example, and this is showing that it was actually posted. Is that the argument?
Yes.
Okay.
I think that.
And it's a cap.
Yeah, I can see what the caption reads. I'm gonna permit that one.
Okay, now here is the, and when I say here, I'm talking about 422Y
Okay.
is the actual post that does not involve anyone hovering over anything that says a date.
Right.
And I know the relevance of the date and the time. And so I don't have any objection to that, but that's the way I believe that these, not some manipulated timestamp on the upper right, but as it appears in Instagram. And so I don't have any objection to 422Y, but going back to that other
Right.
exhibit, which is 397Y, I would say 422Y is more appropriate.
Okay, and it actually, you can see down there at the bottom of the post a time and a date.
This is exactly like when we were talking about the other day where we had the picture with the pop out of the one we dealt with on Friday. We had both the pop out and we had the date and time. When I referenced to the court, we had both. So this is the same situation. So we would be introducing this one, and since it's no objection, we wouldn't have a need unless there's this argument about what date it really was posted to show the other one.
Use the other one. Okay. All right.
So this next one, which is 423Y, that caption is already on 420Y. It appears that he's reposting something that some other individual who I don't know who he is, and I have no reason to believe that he's in this case, SMM body count with an X instead of a C, posted. And if you go back to 420Y, I believe, you see the exact same, I'll never switch up on my brew, I'm not a dub. So that seems cumulative, and quite frankly, I'm not a big fan, and I believe it's prejudicial to have a post by this gentleman, SMM body count, who we don't even know who he is.
What's the state's response?
I'm looking at the. Okay. That's fine. We don't object.
Okay, so they concede.
Or
that
concede,
They will
yes.
not use, what is it, 422?
423.
423Y? 423Y. Okay. Thank you. Next.
So I believe that this is a cumulative.
Which one?
I'm sorry, 426Y, number 31, photo 31, is a cumulative of the group
Hang on,
photo.
that one doesn't open for me. Too many things open. Okay, yeah, that looks like the same thing.
That's a cumulative of 405Y.
We're gonna put up both.
Okay.
Okay. We won't use both, Your Honor. We'd ask that the court allow us to
All right, well, choose now so that we know which one.
choose the one that is 405Y.
Okay. All right, so they will not use 426Y.
Oh, wait, his phone.
Okay.
Okay.
Don't understand the relevance of 427Y.
So there's a relevance objection to this one.
His, it's that he listed his phone number, and his phone number, by he, I mean, Mr. Sledge.
Okay.
is-
So if he refuses to say what his phone number is or was at the time,
Or we could
then
refresh
you'll
his-
use it.
Right.
Okay. Which you could certainly just use it to refresh his
Right.
recollection. Okay. So that'll only be in that eventuality.
Or if he doesn't remember even after looking at it, then we would have to use it.
Sure.
too.
All right, any others? We're almost to the end of this grouping.
Yes, Your Honor, 430Y, which is number 34.
I don't see a 430Y, but okay. Go ahead.
I just asked the whole she was dead. Motherfucker, yeah. I just asked her she was dead, man. She don't even know who dead. She like, you crying.
Who all do we have there?
Don't we have Mr. Williams? We hear the reference to King Slime. Could you play it back again? Sledge right there, Mr. Williams right there, Mr. Arnold, Mr. Stillwell, and Mr. Kendrick,
I just asked the whole she was dead.
Darlington, and Kendrick,
All right.
and Cope. Oh, Mr.
And when's this from?
This was from.
And also whose account? I'd be interested.
What, I couldn't hear what you said.
I'm not sure we know whose account it's from either.
We have it from YSL _Daddy on one.
Who is that? So I, the justification is for these videos has been, oh, it's showing promotion. And we don't even know who posted this.
But we have the people who are in the video who can talk about the video. It's what's happening in that scene itself.
They're sitting at a table.
That he can lay a foundation for it.
Who, and this is going to be Mr. Sledge that
Yeah.
testifies to this?
Yes. And it's in this particular instance, this isn't so much as them promoting their violence. This is them referring to, we believe Mr. Williams is King Slime. This is them.
This is them doing what?
I don't know that we have these particular individuals.
Oh my
all
God, they're not
being
doing anything.
Sitting together. And we believe and can later confirm that it is Mr. Williams' Sky House condo, but we'll confirm that.
Okay. I would think that would be relevant.
What? Oh my God.
All right, so I'm going to overrule the objection to that.
It's okay. It's all right because all of this depends on the jury anyway. So let this crazy crap come in. Trust me, the jury gonna be like, so what?
Just
Who cares?
404Y, which is number 37.
They hanging themselves.
And let me say, let me go back to that one for a minute. Sorry, since y'all don't know who posted it, I mean, if you figure out who posted it, that's one thing, but if not, we don't need to show the handle or whatever of whomever the poster is, okay?
Yes, Your Honor.
All right. Okay, now back to
It's
the
crazy.
next
It's all right though. I mean, like I said, the jury is gonna be like,
The
what?
last one, Your Honor, 404Y,
Whatever.
number 37.
All right.
Yeah, I mean, think about it. If you're on the jury, think about it. If you're on the jury right now, and that got submitted in as evidence, wouldn't you disregard it like as evidence? Absolutely. Absolutely.
What y'all do?
Junk is stupid.
Anybody want to see Monto? I'm here. I don't
They still
lie,
trying to put this
and I
in.
do not
Same old
hurt
stuff.
fuck niggas. You did.
This is the day after the
Right.
Adele Drive shooting
Okay.
that Mr. Sledge and others were convicted of.
What's the objection?
I'm going to withdraw my objection.
Okay.
Right. They're hanging themselves. They are going to overwhelm the jury. The jury is going to be like, whatever. They're hanging themselves. They don't have a case. So let all this crap come in, Judge. Fine. Go ahead. Go ahead. It means nothing. And the jury will know that. It's not evidence of doing anything RICO related. Are you kidding me? A meme? A video of some people hanging out at a club smoking some weed? Yeah, that's RICO for sure. Stop it. Stop it. Right. It's overwhelming. Exactly. And if they don't understand it, they're not even going to put it in play. Like in their mind, they're going to be like, whatever. If you're on the jury, think about if you were on the jury, if you're a juror and that came in. How's that related to RICO gang? How's that related to anything street related? How's that related to anything that they're trying to imply?
The next folder is
goofy.
tattoos, is what that folder is called. Or do we have
Man, they got a
objections
folder
to
of tattoos,
anything
dog.
in there?
This is crazy right here, man. Tattoos, dog. Come on, man.
I mean, looks like a lot of them are the same picture over again. So at least I would think half of them, we don't need the same thing twice.
We wouldn't be putting in
Okay,
multiple pictures
beyond
of the
that, any objection?
Throw the whole folder out.
I mean, I assume he's going to testify that all of these are somehow gang-related tattoos or what? Because if they're just art, then that's not relevant.
we're not going to put in all of them, just the ones that reference or pertain to his. I mean, he'll be here, so we may not
Right.
even put him in at all. He can show the jury.
Well, I don't think I want him stripping down in court.
Not
so.
all the way.
So if he wants to show us what on his forearm,
so
that's
damn
something.
funny?
Otherwise, I'd rather let's use. The
I'm sorry,
picture.
y'all.
Okay.
My bad.
I don't know. I can't get an answer to that. Do you know which ones you're gonna intend to use that you believe are relevant to an issue on trial here? That he can't roll up his sleeve and show us? Yeah.
I think we're not gonna need to use Mr. Sledge's tattoo photographs.
All righty.
And yeah,
Okay.
I don't think at this time.
So I don't know what that, then there's an image that is, oh, it's a video that isn't in the other videos. What's that one? Is there an objection to that one?
I'm sorry, Your Honor, I just messed up my. Your Honor, can you direct us to
I mean, so I opened up the Dropbox and, you know, went to Sledge's folder, and then within that folder,
Okay, I'm sorry, I just clicked on it. I think that's the video. Is it the image?
yeah, 0156, whatever. Yeah. So is that objectionable?
No.
Okay. Any of the other items in that folder? And
If
they're
I'm
marked
Young
with
Thug,
exhibit numbers.
if I'm Young Thug, I'm moving to Iowa, Oregon, Salt Lake City.
Is the court asking whether?
I'm getting up out of Georgia, dog.
I know that the state's position, I assume, is y'all intend to use those and believe they are admissible. So I'm asking if there an objection to them.
So the plea agreement, I've already
Okay.
thinking about that.
Yeah, and so, yeah, it's a little more helpful actually when I looked this weekend to see what it is y'all are talking about. And I would think whether that comes in or not depends upon how that witness testifies. So
When you're saying that comes in, are you speaking specifically?
this, I'm looking at the, whatever it is, December 27th, 2022, several page. It's called plea agreement, but he's initial different factual assertions, and that's the one I'm talking about. It's 396 YC, Y Charlie, Yankee Charlie.
Yes, Your Honor. And the terms of the plea
Mhm.
obviously are fodder for cross-examination.
Right.
I would concede that potentially, depending on his testimony, statements that he acknowledged that would be inconsistent with his testimony could possibly be prior inconsistent statements. I would concede that fact. So I agree with Your Honor that to deal with the admissibility of the factual acknowledgement section, we would need to hear his testimony. My specific concern dealt with number 8, and just as I had concerns about Mr. Zachary and Mr. Copeland, whether they were in their prior statements, whether they were speaking out of actual firsthand knowledge or if they were speaking out of inadmissible hearsay or rumor or speculation. I don't want Mr. Sledge to be cross-examined or to be impeached with a prior statement that was based on that the basis of it was inadmissible to begin with. That's my concern.
Well,
And all I can say, and I'm not Mr. Sledge, so I cannot answer this for Your Honor, but I can say from my understanding from working on this case, that number 8 is not based on anything that my client has told him, and it's not based on firsthand knowledge.
I think that may just be something you'll have to explore because he initialed and signed a sworn statement saying, I personally know this. Maybe he doesn't personally know it and it was a lie, but I mean, they've gotten that there for a reason. And that's just going to have to be something y'all explore with regard to his credibility. You know, I mean, he is right here asserting in this document, I do personally know it.
Well,
So,
I understand what you're saying. And, you know, these are not, I understand he signed it. He did not write it. And so personally, knowing to a layman can mean a lot of different things.
Yeah, he had an attorney at the time, right?
He did.
Yeah, so I think that, yeah, that I can't keep it out on that basis. All right, what else?
We briefly discussed the well, the plea transcript. I don't know under what circumstance that would be admissible.
I would think that would also be a impeachment item, right? Would y'all only intend that for recollection or impeachment? Okay.
Okay, and then we also have a gang profile, which is filled out by someone. I don't know who wrote this. I don't think we know. We've been given a bunch of these. I don't know if we know who wrote any of them, but it wasn't Mr. Sledge.
Right.
So
We would not introduce the gang profile as an exhibit through Mr. Sledge. We may use some part of it to refresh his recollection or something like that. It would be, because it would be a document that details certain incidents that involve Mr. Sledge. And it has photographs of him in it. We wouldn't be just whole hog introducing that.
All right, so this is not gonna go before the jury.
Right.
Y'all may
We would,
potentially refresh his recollection.
It's just
over something like this. Okay. All right. Okay, that takes care of these Sledge exhibits, right?
I believe so, Your Honor.
Okay, so who do we move to next then?
listen.
Sorry, I have to keep reopening the Dropbox for some reason. Is there anything with, I know, looking at the witness list, we've talked about Burnett, Sledge, and Zachary now. Thorpe's gonna be moved to a bit later, so Bean.
Not yet, Your Honor. There was one that we can talk about that I think merits conversation.
Okay.
So Mr. Kendrick pled guilty in 2015 when he was arrested with Martinez Arnold in October 2015, where they had the two guns, one of which was stolen. In the plea colloquy, the prosecutor, as a factual basis, asserted that YSL is a gang and that Mr. Kendrick is a member of YSL. And Mr. Kendrick acknowledged that and agreed to that. And so we intend to introduce evidence of that against Mr. Kendrick during the trial.
Okay.
We're absolutely going to object to the entry of not only that colloquy, but any plea that reflects a gang charge that Mr. Kendrick pled guilty to. Mr. Kendrick, to my understanding, I mean, that's a decision he's going to make, but I have no expectation that I'm going to have the opportunity to cross-examine him. It was a testimonial statement. He was in court. speaking to law enforcement for the purposes of securing himself the best deal possible. And certainly his acknowledgement, admission, or his testimony, I would say, is what it is, out of court testimony, or out of court testimony as applies to this case, affects my client. A element of this whole case is whether YSL qualifies as a criminal street gang under the law. Mr. Kendrick provided testimony to that, that I will not be able to cross-examine. And so we are going to object to any entry of the plea to any gang count and any colloquy during the plea regarding the nature of YSL, according to Mr. Kendrick.
And Your Honor,
Go ahead.
the court can limit the jury to consider that against Mr. Kendrick only.
Go ahead.
That would be wholly insufficient to protect the rights of Mr. Stillwell and the others, quite frankly. A curative instruction or a limiting instruction is not going to suffice. And the state can try to prove their case, but they cannot try to prove their case with Mr. Kendrick's statements during a plea.
Well, I'm not sure that's true. I mean, if it is admitted only against Mr. Kendrick and I am Kendrick's, and I tell them that that's all it can be considered against, we'd have to craft the right instruction, but I mean, it's out there and it's evidence. And I mean, I agree it's testimonial, and so it shouldn't come in against anybody other than him. It can't come in against anybody other than him, but seems that it ought to be able to come in against him. Are you saying there's just no way to limit it?
Go ahead, Mr.
Yeah, and I agree with Mr. Shart. That is asking the jury to climb a steep hurdle. And that's why Bruton says that, yes, you can limit the statement. It used to be, as the court may remember, on a Bruton issue, if Mr. Kendrick made a statement, he made a statement in this case on October 6, 2015, and he implicated Mr. Stillwell, or he implicated Mr. Williams, et cetera. It used to be that there was an instruction given, going back to common law, that it can only be used against Mr. Kendrick. And the court said that's not good enough. In a joint trial, the jurors can't be expected to follow that instruction. It's you said it earlier too. Presumably the jurors follow the instruction all the time. That's what we presume. But in Bruton, that's why we excise or redact.
Right.
And here, it is an essential element of this conspiracy in count one and several of the gang counts that YSL is a criminal street gang. And now you have, and that's what I was saying before, and I'm looking for the cases.
Right.
But for Mr. Kendrick to get up and say, not get up, but for his plea colloquy to say, I am a member of YSL's criminal street gang, that instruction has to be airtight. Otherwise, he needs to be severed.
I mean, I agree that the instruction needs to be airtight.
Or he needs to be severed, or it's excluded. And I gave you a case when you first came on the bench here. I gave you, if you remember, if you don't, I could give another copy. United States versus Vendetti, Vandeti, I gave it to everybody, or at least it's on the court in the state. And I think Mr. Weinstein, and it's 623 F second 1144. It's the Sixth Circuit. It's 1980. It's good law. And I also cited State versus Jefferson, which is 302 Georgia, 435. That's 807 Southeast 2D, 387 2017. and they just stand, and it's State versus Thomas, THOMAS, 364 Georgia PO 148, Division 2, 874 Southeast 2D 195, 2022. But the bottom line, Your Honor, is I would agree with the Honorable Maxwell Sharp that a instruction for that type of, that is explosive evidence that goes directly to the essential elements. So I do not believe that instruction would cure any type of fair
Everybody
trial
put Honorable Max in the chat.
in this case.
Just briefly, Your Honor, we would object to any severance at this point in time in the case.
All right. I mean, I've read Vendetti, and I don't think that it actually stands for the proposition that you're arguing it for right now. I looked at the other two as well. The guilty plea of any non-testifying co-defendant can't, it's not proof of guilt for any of the other co-defendants. I mean, I agree with that, but that's not what it would be offered for. Y'all, the state, need to come up with an instruction that you believe will insulate the admission of the plea colloquy, the part that you intend to, where if he says, yes, YSL is a gang and I'm a member of it, from any Bruton-ish type problems.
Yes, Your Honor.
And we need to do it at, before that's admitted, not just at the end of the trial. It needs to be provided to the jury at the time the evidence is admitted.
Understood.
But I mean, I don't think that the law provides that it needs to be excluded, just that it needs to be appropriately limited.
Put redactions on anything against the other defendants. That's all you got to do.
Law, please forward it to me.
Put redactions on it.
But I don't
How much
think
law
this-
do you need? How much case law you need, Your Honor? Dang.
And let's see. So Thomas, give me those two sites again. Just let me make sure I wrote them down correctly. I think you said 302 Georgia 435.
Yes, that's State versus Jefferson,
Jefferson. Okay.
2017, and then State versus Thomas, 364 Georgia PO 148, Division 2.
Yeah, got it. Thank you. Yes.
And then you offer as well Henderson, just for the court's consideration. Henderson v. State is a Georgia Supreme Court case decided August 21st, 2023, 317 Georgia 66 at 77.
Okay. Is that a new one, or have y'all given me that before? Okay. All right, I'll take a look at it. Okay. So you think y'all may have? All right. For a different reason. Okay, well, I'll take a look at it for this reason. All right, so
This is a huge stall job by the state,
we're
man,
gonna
for
need
real.
to do some work on that one, but those are, I think we understand the parameters. Okay, so I don't know what, I mean, thank you, whomever raised that, but in terms of going through what other groupings of evidence we need to look at in this first 30 witnesses, the next witness that is on y'all's list in order, generally in order is Mr. Bean. Is there anything from him that we need to look at? I think, yeah. No, okay. So no social media from him? I didn't even see him in this folder, but no, okay. And then there's Kenya Morton, and there's maybe an interview from her. I don't know if you.
Her interview would not come in
Okay.
unless she's listed as as the alibi witness for Mr. Kendrick.
Okay.
And we wouldn't be putting in her interview unless it was in the future.
All right, so we don't need to look at any evidence that's going to be used with her, right? Okay. Then Sprinkle, is there anything we haven't already talked about for him that? So he's got a folder. If y'all want to open up his folder. And then within his folder are lots of folders. So hopefully the defense has, in the couple of weeks they've had the folders and months that I guess they've had the evidence, made a determination as to what, if anything, y'all would be objecting to in this grouping of evidence.
Yeah, you can bring witnesses back though if you haven't released them from the case. So that's not shocking. That's not really that deep.
I do have objections, but there's a lot here, so
They still don't have a case, so it doesn't matter what they do. They hang it themselves. we don't
can
need to
discuss
overreact
certain
at this point.
things,
They're hanging
as Your
themselves.
Honor sees fit. I will say I do have objections in this folder, though.
Okay, well, now's the time to go through them while we have some days without our jury.
Yes, Your
So
Honor.
let's dive in.
Okay.
Where shall we start? We've got an Arnold file, two Arnold files, Garlington, Kendrick's, other items, Stillwell, and then some, I don't know, looks like pictures maybe.
I mean, the state is actually trying to put in a meme as evidence. That is crazy, dog. I
Let
ain't
me ask
never heard
this.
nothing like
Is there
that.
something that y'all are more ready on, and then we could dive into this tomorrow? Would that help?
How about you just end this?
Can I discuss?
Sure.
When they're finished, we can make an announcement on the Marquavius Huey motion in limine, so get that off of our to-do
Okay.
list.
Well, we'll wait till after they confer.
So the defense is discussing.
Sure. Why don't we just take a quick recess? That way, if anybody needs to use the restroom, y'all can talk. And if anybody else needs to use the restroom, they can go use the restroom. Okay.
All right. Yeah, about to go to recess. I'm pretty sure it's going to be like a 10, 15-minute recess. What do you guys think so far? How the meme, trying to put the meme inside of the evidence, man? Y'all tried to introduce a meme as evidence? Really? I've never seen that before. That's kind of crazy. That's kind of crazy. All right. I'm gonna I personally have to make some runs to do real quick here for my household here. So I have to take care of some stuff later on today here. I thought they would have been done by almost 3:30, but it seems like they're gonna go a little bit longer. However, I'm not going to be able to finish this stream right now, but y'all can head over to Cat Not Williams. I know Cat Not Williams doing her thing, or AV27 Power. I think she's going live as well. You can finish out the rest with them if you would like. But I do appreciate everybody watching the stream with me and showing love, and those that have become members, those that have paid for memberships that I was not unaware of. I didn't see nothing in the chat, but could have been done in previous videos. I want to say thank you so much for all of your love and your support. Yeah, this is kind of crazy. This trial is worse than Johnny Depp case. Yeah, it is. It really is, Abundance. You're absolutely right. This case is being dragged out by the state, is unnecessary, it's uncalled for. But I'm going to head out, you guys. We've been rocking for about over 4 hours. So go ahead and put that hashtag, that Biz Nation, in the chat. Again, I appreciate all of you all for rocking with me today. And but I'm not sure if I'll be able to stream tomorrow. I will let you all know. I'll probably post something in YouTube and let you all know if I'm able to do a live stream tomorrow. But if not, then I'll probably be over there at Cat Not Williams, man. I know she'll be rocking out, man. She do her due diligence all the time. And she's a great supporter of the channel. So thank you all so much once again, man. I'm about to go ahead and head out. But you all stay safe, be cool. I'm gonna holler at y'all in a minute, man. I might see y'all over there at Cat Not Williams real quick. All right. So after I finish my runs, I'll come back and then Cat Not Williams, man. I holler at her in her chat and rock with the people. But I appreciate you all. I got nothing but love for you. Thank you so much once again for just rocking with me. We had peaked out at like 60 people at one point, man. We was rocking out for a minute. I was like, we gonna get 100? Will we get 100? You know what I'm saying? But we're gonna hit that 100 one day. You know what I'm saying? We almost at 1,000 subscribers. So go ahead, like, share, subscribe if you haven't done so already. And it's nothing but love here, man. It's all love. A small family, but a loving family, man. It's your boy Tay Biz. I'm gonna holler at y'all. Peace.
Hey. No stress, no biggie. Baby, I'm just too jiggy. Better know I brought that with me. Case they get too iffy. Baby, don't stress, don't sweat it. Put it all on my daddy. Know how I'm coming. And they know what we had. Run around through that left side, low end. All of mine need more wins. If you got beef, don't come out. Cause my young hitter might go in. Uptown GN. Working all through my weekend. Hoping it don't show out. Cause all of my hitters too deep in. With a boy, I'm so seen. Ain't worried about long as my money and my green. Baby, I ain't got work tomorrow. Tell me what the business is. Ain't about no club hop. I'm trying to start some businesses. Shorty, you thought it was, they better know it's not that. Talking all that online, they knowing that it's not fake. Sliding through my hood, I make maneuvers like a Uber, baby. Got a 10-year plan, these can't tell what they doing lately. And I'm way too clean, I'm Listerine, I thought they been knew it. All in my lungs, I got my red cup full of that Henny fluid. Young middle Mad Mac, I'm swinging that leg, I'm banging that do or die. And I ain't that leave before I get crucified. Living in my bloodline, this place in my family tree. How the they pressed, I did my best out of what they handed me. Straight out of that country, know my shawty dick as human air. And I need not mention no extensions, that's human hair. Boy, we grew in there.